Well, I'd like to call this meeting to order, our July 2019 meeting of the Tennessee Real Estate Commission. And at this time, I'd like to ask Ms. Rihanna if she will read the public disclaimer into the record.
Notice of the July 10th, 2019 meeting of the Tennessee Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since September 18th, 2018. Additionally, this month's agenda has been posted on the website since Friday, July 5th, 2019.
Great, thank you. And would you do the roll call for us, please?
Yes. Commissioner Jeff Diaz.
Present.
Commissioner Rick Douglas. Commissioner Marsha Franks.
Here.
Commissioner Diane Hills.
Here.
Commissioner Austin McMullen.
Here.
Commissioner Fontaine Taylor.
Here.
Commissioner Bobby Wood.
Here.
Chairman John Grease.
You'll be here shortly. Okay, thank you. I'd like to ask Austin McMillan if he will do the prayer and pledge with us. And at this time, too, I would like for us to be in remembrance of Officer Anderson, who was killed this past week in Nashville. And our condolences to his family and the Nashville Police Department.
If you'll bow your heads, please, we'll begin with a moment of silence for Officer Anderson, and then I will pray with us. Let us pray. Heavenly Father, we come before you now and are mindful of all your servants and those who serve these great people. We pray that you would strengthen them and give them courage as they serve each of us with honor and make our society and our community better places. We pray that your Holy Spirit would be upon us in this body as we meet today. Give us wisdom to bring honor to your name, honor to the people of this state, and to serve this profession in a way that it would be empowered to serve our communities and make them better places for everyone to live. We also lift up those commission members who cannot be here today, and we pray that you would be with each of them and their families, strengthen them. We pray this all in the name of your Son, Jesus Christ. Amen. Amen. Will you stand for the pledge, please?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, thank you, Commissioner. Now we're going to entertain a motion to approve the agenda.
So moved.
I would like to add something. Second.
I'll second it.
Okay. Any discussion?
I'd like to make an addition.
Okay.
And you can place it wherever you'd like in the mission discussion, I guess.
Okay.
50-mile rule.
All right. Add that to commission discussion. Anything else from anyone?
I would like to just, I wasn't here last month, and I know y'all talked about the education roundtable that we had, and I'd just like to talk about that a little bit at some point whenever you're ready.
Ross is not down here yet. Do we know, is he here today?
He is here today, but he's not made it in yet.
Okay. All right. So,
Maybe under Education Director's report.
Yeah. All right. Anything else?
I'd like to, this was supposed to be on the agenda to talk about our sunset hearing that's coming up in August. So if we could put that under the commission discussion as well, please.
Anyone else?
Also, we have an individual here that was going to make a formal appearance, but an informal appearance. I apologize, but they currently were not on the agenda, and we did not receive notice of this confirmation until last night. I'm told that they are here with their principal broker. Is it?
I see one person in the room. Okay.
Yes, so they're here with their principal broker, and I wanted to know if the commission would like to put them on the agenda under the informal appearance section.
Okay.
Is concerning this letter?
No, it's not concerning the leather. It's an additional person.
And does the state have all the information they need for the presentation?
I believe they brought a letter with them, so
I'm talking about our attorneys. Are we prepared?
I don't know about it. I learned about it this morning, so.
It's not typical that we allow people just to show up, but,
I have something.
okay, Mrs. Taylor.
Because there has been a prior incident where people showed up and without going through the proper channels, and it caused a lot of confusion and trouble here because of the way it was done, and I would rather not listen to anybody unless it goes through the proper channels.
Like to make a motion?
I make a motion, it's a negative motion, but I'm making a motion.
I think we should have a motion or not, though.
That we do not hear anybody unless they come through the proper channels. And to me, that with notice and everything to us and to you.
And any explanation why it just came up last night or this morning?
I will have to consult with Mr. Smith on that. I just found out when I arrived today, so I don't have any further information.
Were they told to come, or were they told it was okay to come?
I think they were, as most individuals for informal appearances, we require certain information from them, and we reach out to confirm with the individual, and we didn't receive confirmation until last night.
Is there a deadline? Do they know of the deadline?
Usually we try to reach out and make sure of individuals that confirm with us prior to us sending information to you all Friday before the meeting. So it would be on the agenda otherwise.
Any other discussion? All those in favor of the motion, say aye.
It was for them not to come, right?
Right, for them not to appear.
Right.
Aye. All those opposed? All right, that motion is unanimous.
Thank you.
Okay, anything else to be added to the agenda? Or taken away, or any changes? All right. All right, then let's vote. All those in favor of the agenda as edited, vote aye. Aye. All those opposed, vote no. That motion carries unanimously. All right. Now we're on to the approval of the minutes. Is there a motion?
Motion to approve.
Second.
Okay. Are there any comments? I wasn't here, but I did read I wasn't here last month, but I did read the minutes. And under the education report, at the very end where it says note, it says that Grease and Douglas voted again, and I think that should have been probably against
That's correct.
instead of voted again. So we probably need to alter that. All right?
Marcia, may I make a comment?
Yes.
Because you brought that up, it's common when we make a motion that they note who's making it, so to put in the minutes.
Okay, I should be saying
Yeah,
those
right.
things. Okay.
Thank you.
Okay. And who made the motion that we approve the minutes and who seconded it that time?
Diaz moved.
Diaz and
Was it Taylor?
Taylor.
Taylor seconded.
All right. All those in favor of the motion, say aye.
Aye.
All those against, motion carries unanimously. Okay, the next thing on our agenda is an informal appearance with Mary Williams.
So this isn't really an informal appearance. It's the letter that you should have before you from Miss Williams. Would you like me? I'll read that into the record just so everyone is
Okay.
aware of it. It's a title to the Tennessee Real Estate Commission, to whom it may concern. The purpose of this correspondence is to appeal the renewal/expiration of my affiliate broker's license. According to the Trex records, my license expired on April 1st, 2017. In researching this matter and speaking with Belinda Rivers, a representative from the Tennessee Real Estate Commission, I learned that a renewal notice was mailed on January 2nd, 2017 to my old address. Address is listed. The letter was most likely returned to the Real Estate Commission since I have not lived at this address since May of 2012. I never received notification of the expiration. I attended a Tennessee Real Estate Commission public meeting in May of 2016 to reinstate my license previously. My license was successfully reinstated. At that time, I am certain that I mailed in a change of address to reflect my new mailing address. Address is listed. However, because my old computer is no longer operational and my files were lost, I am unable to obtain that correspondence to confirm the change. If you'll refer to the attached trail of emails to Aaron Smith, you will see that I did notate my updated mailing address in the closing. If necessary, I can forward you the actual emails. Because I have been licensed since March of 1980 and grandfathered, it is most important that I'm able to renew my license. I retired from my full-time position as a professor of business management at the University of Akron with 30 years of service in June 2018. I previously worked as a training coordinator at the University of Tennessee Human Resources Department prior to relocating to Ohio, in addition to maintaining my Tennessee real estate license. When I moved, I placed my license in retirement, always with the intent of reactivating it and returning to working in real estate in Tennessee. Therefore, when I went online last week, I was surprised to learn that my license had expired, which of course affected me greatly. Since it is so close to the 2-year period from my 2017 deadline, as required by Tennessee law, I would greatly appreciate if the Commission would consider my request to renew my license. If there are any steps to take and fees to pay, I would be willing to do that. Sincerely, Mary B. Williams.
Okay. Do we want to discuss this? Do we want a motion?
Can I ask a question? Is there a way to go online and update your address through the website?
Yes, the Trek 1 form, everything is available for you online.
And whose responsibility is it to make sure that we have correct and current information?
It's the licensee's responsibility.
Okay.
So is this person asking for a waiver of fees, or are they asking for something else?
It seems like they're asking to renew their license so they can maintain their grandfathered status, but I don't think that's possible, especially since the license expired in April of 2017. It's far past the 1-year renewal mark. Also, I don't know if these emails that she's provided have been edited in any format, but looking at them, I don't see where she explicitly stated in her email that she has a new address other than providing it in her signature, which would not let anyone know that her address has changed unless we were looking at that online. So I think that's what she's asking, is to be able to renew her license and take any fees, but per the rules, I don't think there's an avenue other for her to retest, reapply, get as required past the 1-year mark.
So this is actually out of our purview to allow it in the first place, and especially I would say since she's already had to reinstate her license in 2016, and because she thinks she's grandfathered, doesn't mean that she's grandfathered, and actually she's not, because we don't grandfather affiliate brokers. So do we have a motion on this informal appearance?
And it's a negative motion.
It's okay.
I make a motion, we not approve her for renewing her license.
Second.
And we have a first by Ms. Taylor and a second by Ms. Hills. Any other discussion? Okay, all those in favor, vote aye. Aye. All those opposed? Motion carries unanimously. All right, next is our Education Director's report.
Yes, ma'am. Thank you, Madam Chairman and Mr. Chairman and members of the Commission. Good morning.
Morning, Ross.
I want to present the education report to you this morning. I believe it's on your iPad there, and I have reviewed the all the providers, the instructors, and the courses for J1 through J33 for this morning. I present them to the Commission for your review and approval.
Is there a motion?
Motion to accept.
Second.
All right, we have a motion and a second. Is there any discussion? I would like to make note of J13. This is about opportunity zones. This is something new across the United States, and it's a great opportunity. I know of one large developer in Memphis that's using this for a large development. I would encourage all licensees to Google opportunity zones, and they can find out in their local areas through their zoning commissions, where those opportunity zones are. Those are zones that each state has X amount of zones allowed to them, and they take particular places where they want to help those areas to have more growth. And so there are several in Tennessee, and I would just recommend that all licensees look this up, opportunity zones, because it's opportunities for the public and for licensees as well. Okay, if there's no other discussion, so we have Diane made the motion, and who seconded that motion? I did. Bobby. Okay, Bobby did. All right, all those in favor, say aye.
Aye.
All those opposed? Motion carries unanimously.
Thank you, Mr. Chairman.
Also, we added to the agenda, Bobby and I both were absent last month, and you gave a little update on the roundtable discussion, and we were interested in, if you would be so kind to fill us in on that. And
Well, no,
do you have
I
particular
heard
questions?
from last time. I was just going to say stuff because I was
Okay.
actually at the round table.
Okay,
And so
okay.
that's what I was going to do.
Okay.
Because the thing that I came across, two or three things. One, I was surprised. I thought the instructors really liked the round table and getting together, and they really appreciated the Real Estate Commission listening to them, and they didn't think they had that opportunity in the past. So they really liked that. Also, the thing I was surprised how many people, not only in that group, but also other people actually watch this video. And they're not here, but they're watching the videos. And so, because they were commenting about it and said they watch it to get material and get updates for what's going on in the real estate industry. So that was impressive too. The other thing is, and I know a couple years ago we took upon for pre-licensing to actually start publishing the results for each real estate school. And they are watching that. And they're keeping up with that, and even to the point of there was one real estate school that pointed out that they had someone that had tried to take their test that they give at the end of pre-licensing. I think she mentioned 4 times, and the person had not passed their test, and they're like, please just let me go on, and I will, I'm sure I'll pass the PSI exam. And they're like, if you can't pass ours, you're not going to pass PSI, and we don't want you being a ding on our rating. Mm-hmm. So I think it's working, what we're doing on that's working. But the other thing that they brought up, that one of the real estate schools talked about, that they would like for us to maybe look at, was that there is no time frame, they're saying, and I think Ann and I'd communicate with her about this, but there was no time frame from when you take your classes to once you do that, you can take your PSI exam at any time. and because of that, they think that that's a problem sometimes.
I thought that there was a length of time that you have that you did take it.
We didn't see that.
Are you saying you could take it in 2016 and not test till 2019?
Right. There is a time frame of once you've tested to apply. So you have 6 months after taking the test to apply. So I believe that's what you're referencing, but in the rules and statutes, there's I could not find anything that says you have a certain amount of time to take the exam.
Oh, but in the PSI, and we looked at this a year or so ago. Is it addressed in it? Remember all the
We probably
requirements?
would probably have to look and see what the PSI rules are.
Right. So PSI, they, as the testing vendor, or whoever the vendor is that we award the contract to, has the ability to set certain procedures. So it may be in their procedures, but my understanding from the roundtable is that I don't believe they have one. So that might be something that we want to address with our providers in the future. But I will say there's, for a lot of different professional testing, there really kind of isn't a time limit of when you have to take the test, so I don't think that's necessarily out of the ordinary.
But once you've taken it, you have to sign on with the broker within so long.
Right, so once you've taken the examination, you have to apply to the commission within 6 months of that examination. That's the time frame.
So Ross, is that something that you could look at and check with PSI and get back to us next month on, just so that we are clear about that, since the question has arisen and we don't know the answer?
Yes, ma'am. We can do
That
that.
would be
Because
great.
we reviewed that.
We
and
have.
made some updates.
I just want to confirm what Anna's saying, and we've been dealing with that for several years now, but that same question comes up again.
So what would we do if we wanted to change that? What would be the procedure, and is that a statute
It's
problem?
I'm not sure if it's
Could be a
statutory
rule.
or if it's rule, but I do also think that it could be something that PSI could do on their own, since the
It'll be
testing.
easier to go through that then.
Yeah, so it would probably be something that we might want to require in the next contract for an educational vendor.
Bobby, did that answer?
Oh, that's good. That was just something I learned from it, and that they knew it. But they knew that answer right off the top of their head about that. But they talked about that. Question I asked was, it's been pointed out in one of these meetings from a vendor or educator that saying that all the schools were basically not grading tests, final exams, and giving answers and stuff, and they point blank said, no, that's not what they're doing. They're not doing that. So.
So this is something that you would recommend that we do again in the future, and if so,
Oh, yeah.
how
I think
often
they
should
would-
we do it?
They would love to do that. I think annually is okay. I don't know that it needs to be a whole lot, but I think at least annually.
Okay.
And this whole table was full of people, and had a couple sitting out there too, but it was full.
At a microphone, basically.
Yeah.
That's great.
I was trying to see if there's anything else. It's interesting. One thing that they mentioned, they thought that maybe we had made a mistake. One of my last notes on there, and it was interesting that it was brought up about today, was they thought we need to revisit the 50-mile rule. That they thought we made a mistake on that. That was pointed out in that class. And then let me.
And
see.
why did they think that was? Well,
Lack of supervision, but we can
Okay.
talk about that later.
Okay.
But that was the thing they talked. And they also thought there was a disconnect. We talked about why the pass fail rate is so low, and their problem is part of that exam is a national part, and there's things there that just don't apply to Tennessee. But that's just part of examination, and didn't really know a good way unless we wanted to develop our own test, which I don't think anybody has a stomach for.
about 2 years ago, I don't think you, it was Janet DeChara and I actually met with PSI, and they do it about every 2 years. And we went over every single question and to pull out that doesn't apply to Tennessee or this should be worded differently. I mean, we spent all day. So that is something that so, you know, if there was something that group found that was incorrect, I mean, we could get in touch with PSI and let them know that doesn't pertain to Tennessee. So.
I think some of the real estate schools had specific things that people had come back and told them about, and that they had not heard of, and so didn't know if that was something that they could get information from PSI, or they just didn't know how to go about that. They just thought that maybe sometimes there's things on the test that they weren't aware that we were being testing on.
I doubt that they can just call PSI and ask them the question. What do you think, Ross? But I mean, it is something that they could direct the question to Ross and he could find out.
I'd be glad to facilitate that, but we've got great response from the PSI representative, Kathy Layton, and I've been able to ask her any numbers of questions and details from across the state from licensees, and she gets right on it and answers back. So we do have some good representation with PSI.
Trying to remember the man's name that was in charge for years that did it, that conducted that meeting with us. I can't think of his name. But he's retired, and so she's the new person. So maybe it's getting time that we have another one of those meetings. I would love for us to be able to handle it on a case-by-case basis rather than having to go sit all day and look at all the questions, but that was kind of grueling. So, okay. Anything else?
I think I'm done.
Okay, on the Education Director's report, we also had Jill Malloy.
Yes, ma'am, Madam Chairman. Also, at the end of this education report, I had one discussion item I'd like to clear out just as a part of the matter before you, but it was from, let me see here, request to, it's the very end of the report, it's under discussion, Real Estate Coaching Simplified, Michelle Moore contact. She had requested that the course that is now on the books is a 1 hour. She was requesting it be a 2. She hasn't given this course, but that the information she provided was for a 2-hour course, and I think it was in error that the original materials were sent with 1 hour. So she's requesting of the commission that she be given 2 hours for that course instead of 1.
A motion?
I'll make the motion.
Michelle Moore is given permission to have the real estate coaching simplified number 16.
I'll second it.
Okay, great. We have a proper motion and second. Is there any discussion? All those in favor?
Aye.
All those opposed? Motion carries unanimously. And then we
Madam
need to do the instructors.
Instructors, yes, ma'am. I present the instructors to you this morning. I think the bulk of them fall under, as Commissioner was discussing, the zones. I believe that that's what you'll find. A lot of these folks are from, well, some are from in-state, some are from out-of-state, but basically they're coming to discuss the introduction to opportunity zones in Tennessee and Kentucky, some case studies of public and private partnerships in real estate and tax updates. So a bulk of the instructors on your bios are from that course. Or from that
Checked all of their qualifications and everything that they need to do, and it's your motion that they, not motion, but that's your recommendation
Yes,
that we
ma'am.
approve them all.
They
Okay.
are all in order.
All right. Is there
Motion
a
to approve.
Second.
Okay. We have a motion to approve, and all those in favor, say aye.
Aye.
Aye. Those opposed? Motion carries unanimously. Okay. Next, we have the Executive Director report.
Madam Chair,
Yes?
I do believe that we haven't disposed of the Jill Malloy matter.
What?
The Jill Malloy.
Oh, I'm so sorry. Yes, you're right. Okay. Okay.
Now, I think that was placed on the commission's agenda after following a subsequent motion to consider it at this meeting, the effects that could have on other courses by not allowing Ms. Malloy to teach this course, who, in my estimation, is competent and has the credentials to be able to teach this from a factual context. She's not going to give legal advice. So as we begin the discussion, if the commission has any questions, but I have several documents I can pass out that where I discussed this with CE Shop and with Ms. Malloy, that they wanted to provide some justification for her to be allowed to teach these other courses. Again, it's not for legal advice. It's strictly factual, and she does teach the course in some 8 other states rather than Tennessee. But I do have some documents to. And
so in the minutes, I didn't have much information about what was going on at the meeting and what was the concern and why was it passed to this month.
Well, I wish Commissioner Douglas was here. I think we could get a little bit more, but maybe Commissioner Diaz could say.
Sure. I think this started with me just asking a question. Last month's education report had a lot of courses that dealt with different aspects of the law. That is great information for our licensees and our agents. And Ms. Malloy stood out because as the instructor, I looked at her education background, and since she was going to be teaching courses that touches on aspects of the law, I noticed an absence of a JD or a license to practice law in the state of Tennessee. And I just posed the question, I go, is there a chance that as an instructor she would wander into practicing law without a license as an instructor? And that set off this whole conversation about what qualifications our instructors need to teach specific courses. So that was the question that I posed. It has nothing to do with Ms. Malloy. It's just a question.
What was the consensus of the group, of the commission? To put it off till this month, so you were waiting to get his information?
Well, the commission basically voted no to allowing her to teach that class, like a 5-2 vote. Mm-hmm. And subsequent to that, we decided, or the commission as a body decided to put it back on this month's agenda to see if there's additional information or discussion. I think that's why it's here.
Thank you, Mr. Chairman. That does sum it up. And I do have some additional information if you'd like to see it. One caveat is that CE Shop provides, as well as other providers, a disclaimer when you have a course that has some legal information. But the disclaimer states that the instructor is not going to be giving legal advice. Rather, it's factual, and that for any true legal matter, they need to consult with an attorney. And that I have the disclaimers and so forth here for each of those courses. There were 4 courses in total. 3 courses were she was disallowed on, and 1 course she was approved on. All the courses themselves were approved. It's just Ms. Malloy being able to teach or not the other 3.
Oh, actually, I would say any CE credit given to a licensee would have some sort of law attached to it, because, I mean, if you're talking contracts, if you're talking most any class, I don't think it should disqualify somebody to not have a law degree, unless maybe it was a real estate law class that they were teaching. Is that what Ms. Malloy was going to be teaching, is a real estate law class?
No, ma'am. No, she was going to teach these courses that are essentially they're factual in nature. Factual information is provided. She is not an attorney, nor does she say she is one. But she has excellent credentials. I have spoken with her, and again, CE Shop as well is supporting the notion that she be allowed, because again, these courses are taught in other states, same course, with that same rationale that you use there.
What are the names of the classes?
classes in consideration of taxes and real estate, what you need to know, sex in real estate, sexual harassment, sexual discrimination, and fair housing, and assistance animals and fair housing.
The scenario that brews in my mind when I think of somebody taking these, of a licensee or an applicant taking these classes, is I can hear a student presenting a fact set in a live setting, or asking a question online and saying, in these facts, am I okay in the law? And the only thing the instructor is able to say at that point is, you need to consult an attorney.
Instead of their interpretation?
Instead of their interpretation of law. So, it's just as a licensee, we have licensees that wander into practicing law. We have licensees that wander into practicing in a different state, practicing real estate in a different state that they're not licensed to practice in. So I pose the question for that reason.
And I'd just like to say, in my review of courses in the last several years, if it looks like, or if there's anything in there where it's going to require an attorney, I'm an attorney, I think I can make that determination, then I'm going to suggest that person send me a license, show me that they're licensed and have the credentials. But when you have courses, and we have many, including some of the elements of our 60-hour course, you have contracts and agency and so on, you have legal issues that could come up, but legal advice is not being provided, rather it's factual in nature. And so that's, in answer to your question, even from last month, I think that's where we are with this going forward.
Skills?
6213-324, real estate continuing education instructors. For clarity, because of my voice, I'm going to ask Commissioner Diaz to read number 5.
If the course concerns the law of real estate, has graduated from a law school accredited by the American Bar Association or approved by the State Board of Law Examiners. That's what paragraph 5 says.
Or what they're supposed to.
Right. It says, and Part A says, in order to be eligible for approval by the Commission, a course in real estate designed to meet the educational requirements established in Section 6213-303 shall be under the personal and direct supervision of an instructor who, and then Part 5, as I read it.
Yes. If the course involves real estate and or law that is going to result in, I think, the idea that you've got a legal, or that somebody's asking a legal question, and they're wanting a question involving a set of facts that would lend itself to having to have a law license, then by all means, you can, as you review the courses, you can determine that. But if you need a law license to teach that course or not, number one. But number two, if a question like that is asked, whether it's online or whether it's in a classroom, then that instructor and falls on the disclaimer that they cannot answer a legal, they can't give legal advice. So if it's a factual question, I think they can answer that based on the materials that are provided. They can say whether or not something is in there or not. They can read, as they present the course, and the student can read. But that's pretty much as far as it goes. And that's the determination that I make on each thing that I look at. And in the past, I've had to suggest and tell folks that they've got to get, I can't present this to the commission. You'll have to have a law license to teach that. And that's the situation with this.
So, are you asking us then to approve those, was it 3 classes that weren't approved last time?
For her to teach those 3
For her
classes.
to teach them?
The classes are approved. CE Shop has presented documentation showing that they're approved in 8 other states for Ms. Malloy to teach.
But she's a new teacher in this state?
She is.
Okay, she's never been approved before?
She's been in Virginia and several other states, but right. And those 3 courses, she just needs the commission's approval to teach.
Okay, so I guess we need to know, how does everybody feel about this?
I think Fontaine's on.
Fontaine.
I was going to ask, you said before she was approved for some places but not approved for others, correct? Is
No,
that what
ma'am.
you said?
She's approved in 8 other states for this same course.
For everything that you've talked about?
Yes, ma'am. For these courses, and I have the document here from CE Shop. Talk to CE Shop, talk to Ms. Malloy again, explain the situation. So they're waiting for the commission's advice.
Reading the titles of those again, I think I have them, but I want to make sure.
Yes, ma'am. Well, there, of course, is on the June docket.
We don't have that before us, though. We don't have that.
Right. It's taxes and real estate, what you need to know, sex and real estate, sexual harassment, sexual discrimination, and fair housing. The third was assistance animals and fair housing.
So we've already approved her to teach another course, but not those three?
The fourth course that was asked
So she's
was,
an approved instructor then?
yeah, she's an approved instructor.
So what are we discussing today?
Just those 3 courses, whether or not she can teach.
I
or
thought
not.
if you're an approved instructor, it's not course specific.
No, I think you have to be approved for the course, I think.
Well,
do?
but this is fairly an anomaly here because the commission disavowed. They voted not to allow her to teach those 3 courses because of the possibility that she'd be giving legal advice. Or at least that's not maybe she, but just courses in general. I think Commissioner Diaz had that as and that's a great question. But it's part of my duty to provide the commission with my impression of all these things, and that's what I'm saying here today.
Is there a statute or rule that says that it's course specific? Because we never revote on anyone. On most of these courses, we don't revote on the people because they've already been approved for other classes. So I'm confused why it's course specific now.
Well, because of the issue about the legal advice or not.
I
on these
understand, and
3
I understand
courses.
that's why he wanted to pull it out.
Right.
But I'm just wondering, do we have? I mean, we have to be consistent with these things. So I'm just wondering. I mean, is that something we want to do? Mr. Diaz, what are your thoughts now on it?
Well, having thought some about it, having a month to think about it, I think she should be allowed to proceed and be an instructor for those courses. But I still have concerns. It doesn't put my mind at ease, but I think with with Mr. Ross's assurances that she's not going to wander into giving legal advice in the coursework, I would be okay with her proceeding as an instructor.
Okay, and I would just say this too, that anyone that's teaching an approved class that's approved by this commission for continuing education, all instructors need to be on their toes about when they start dipping into the law elements, and we would want to persuade them to be careful as they walk down those paths. So I guess...
Was that a motion, Jeff?
Sounded like it.
I'll move to approve Jim Malloy for the 3 classes.
Second.
Okay. All right, we have a motion to approve by Mr. Diaz, a second by Mr. Woods. Any other discussion? All those in favor?
Aye.
All those opposed? Motion carries unanimously. We're going to take a 10-minute break, please.
Thank you, Commissioner.
We're going to get back to the agenda. And we are ready for the Executive Director's report.
iPads if you have any questions.
Anybody have any questions about it? Any comments?
Well, I'm just looking at the percentages again. Bobby brought this up once about who passes and fails, and it's always very interesting to me. If you notice, Tennessee Brokers National is 50.60% failed, and Tennessee Affiliate National 52.2% failed. That's a comment that I think is interesting, and I don't understand why. But
I think it's not everybody needs to get a real estate license.
well, that may be true,
Obviously.
but
Well, and that was, well, I was debated on whether to say this, so I'm going to say it. That we asked that, why is the failing rate so high? And the real estate schools really felt that maybe there was they were not getting the quality of student that they used to get. And that, everybody's kind of like, well, you're kind of in between jobs. Why don't you just be a real estate agent? And they're getting a lot of that kind of stuff, not people who are coming to do this on a career, but just to do something in the meantime, and they're not really dedicated to it. And
A lot of people think it's an easy profession to make a lot of money, and they don't have any idea what's entailed.
well, I'm going to bring up this, curtailing all this. That the percentage of pass and fail is interesting to me, and I've just said too many fail, but I've also I would say I don't think our education is up to what it should be, and by that, by terms of study and everything else, I think it's probably, that's why everybody thinks they can be a real estate agent, because it's so easy. The hours, don't have many hours to take to get it, and it's just an amazing thing to me. And I see real estate agents all the time that don't know what they're doing. Now, there's full of professionals, full of wonderful people, but there are a few still that still don't know what they're doing, and I don't know whether that's the education, they didn't pay attention, or their broker's not doing what they need to do, or what it is, but that's my comment.
well, as you look at the numbers, you got 52% last month that failed the national part of the exam. You have 24%, almost 25% that failed the state part. So you figure at any given time that test has been taken, approximately 60% of the room is flunking that test. And that's not just people taking it the first time. That also includes people taking it second, third, fourth time, and it's still a 60% flunking rate. That's concerning.
It is. Mm-hmm.
But I think it's the correct implement to keep those who out of the profession. I mean, that's what an exam is for. I mean, whether it's law or real estate or cosmetology, you got to pass the exam. So, any other questions about that? I wanted to ask, so I saw that the last month's minute said that Arello had been approved, Rihanna. And who was approved to go? Who remembers?
He was.
You were? Okay. Okay, and what about Ross? Was Ross approved to go? Okay, great. The other thing too, Rihanna, is that we need to start thinking about the 2020 calendar. I can't remember exactly what month that we usually do that, but we're 6 months out, so we probably need to maybe start looking at that for next month. And what we typically do is get all the National Association of Realtor, all the Arello, all those dates, any TR dates. And then the other thing too is if it's not, we don't want Fanfare Week, things like that, that would Nashville's packed, which, that's every other week now, but just some considerations for that.
The NFL draft, we don't want
Yeah,
that.
the NFL draft. Okay.
Taylor Swift
Anybody
concert,
else? I think we had 364,000 at the 4th of July. So, yeah, for the fireworks.
4th of July.
Yeah. So, any other questions you may have of Rihanna? Rihanna, how are things going? I know y'all miss Caitlin. How are things going?
They're going great.
Okay.
They're flowing right along.
Okay, great. She had y'all well prepped before she
Yes,
left,
ma'am.
I'm sure.
Yes.
Okay. Well, we appreciate y'all, and we miss Caitlin, but we appreciate the great job that you all are doing. Okay. So next, we're going to go on to the consent agenda. Let's all get that pulled up. First is Ms. Bridges. Do we have anybody else on the consent agenda, or are you doing the whole thing, Kelsey?
I'm sorry.
Are you doing the whole consent agenda, or is...
I'm
remember.
going to start doing the whole consent agenda,
Okay.
and if there's too many, Anna's going to jump in to
Okay,
help
but
out.
we're not expecting another attorney, I guess is what my question
No.
was. Okay. Okay, so would you like to go ahead and read those
Sure.
numbers into the...
I'll go ahead and read 1 through 25, and then Anna will read 26 through
Okay.
the end. All right, number 1 is 2019-004531. Number 2 is 2019-005091. Number 3 is 2019-005481. Number 4 is 2019-005431. Number 5 is 2019-005461. Number 6 is 2019-005271. Number 7 is 2019-06691. Number 8 is 2019-006561. Number 9 is 2019-007241. Number 10 is 2019-007201. Number 11 is 2019-007221. Number 12 is 2019-008641. Number 13 is 2019-008581. Number 14 is 2019-008591. Number 15 is 2019-008441. Number 16 is 2019-008721. Number 17 is 2019-003521. Number 18 is 2019-003861. 19 is 2019-004831. Number 20 is 2019-004841. 21 is 2019-005151. 22 is 2019-005891. 23 is 2019-006111. 24 is 2019-006141. And 25 is 2019-006051. And then Anna will read out the rest.
26 is 2019-006021, 27, 2019-012851, 28, 2019-011451, 29, 2019-011391, 30, 2019-010341, 31, 2019-010881, 32, 2019-10861. Hold on a second. 33, 2019-011581. 34, 2019-011961. 35, 2019-012711. 36, 2019-012121. 37, 2019-014121. 38, 2019-12161. 39, 2019-012101. 40, 2019-013061. 41, 2019-009021. 42, 2019-009311. 43, 2019-009321. 44, 2019-009581. 45, 2019-009571. 46, 2019-009821. 47, 2019-013041. 48, 2019-009161. 49, 2019-003531. 50, 2019-003971. 51, 2019-004201. 52, 2019-008941. 53, 2019-008411. 54, 2019-009261. 55, 2019-009461. And 56, 2019-008621.
Hey, thank you. All right, Commissioners, are there any that you want to pull out for discussion? Bobby?
I had 1, 9, 13, 15, 17, 32.
Anyone else?
2, And let's see, Bobby said 15 and 40, 2 and 40.
Okay, and I would like to pull out number 20. I also have down number 40, so. All right, so is there a motion to approve the consent agenda?
I make the motion to approve the consent agenda with the exception of 1, 2, 9.
Second.
Okay, thank you. All those in favor of that motion?
Aye.
Vote aye. All those opposed? Motion carries unanimously. Okay, Bobby, number one.
I pulled this out not because I have a problem with it, but I pulled it out because I think it was a perfect case, and there was a perfect summary and a perfect everything. And Kelsey, I hate to ask you, would you mind just reading it because it's perfect?
Sure.
And I think there's a lot of instructors and agents that would need to hear this.
Sure.
So,
All right. This is 20. Sorry, are we ready?
Yes.
Okay, this is 2019-004531. Complainant submitted an offer to purchase a property listed by respondent, a licensed affiliate broker. Complainant alleges respondent failed to inform the seller that complainant accepted the seller's counteroffer prior to the seller's revocation. Complainant placed an offer on the property on January 13th. On the 14th, the sellers proposed a counteroffer, which had a deadline of January 15th at 7 p.m. The same day, another interested buyer informed both the seller and respondent that they wanted to immediately place an offer. Respondent told them about the pending counteroffer, but not the terms, and stated that they would first need to speak with their broker. Respondent then prepared a notice of withdrawal for the counteroffer and, per their client's instructions, delivered it to complainant's agent at 9:44 p.m. on the 14th. The following morning at 10:40 a.m., complainant's agent emailed respondent the signed counteroffer. Complainant argues that the counteroffer was accepted when it was signed, regardless of whether the acceptance had been communicated. The counteroffer contains the following language: until notice of acceptance is delivered, the subject property is still on the market for sale, and this offer may be revoked at any time with notice, and the property may be sold to any other party. Council recommends this matter be dismissed.
I'd like to make a motion to approve council's recommendation to dismiss.
All right, we have a motion by Mr. Woods and a second by Mr. McMullen. What was your, was there any comment you wanted to make about that?
I mean, that's and as I teach people and stuff, people think you just sign it and it's good, but you have to communicate acceptance back to the other party, and that's exactly what happened here. They signed it, but they never communicated it, and the withdrawal was done before it was ever communicated back. So that's why it was perfect, and that's why all the real estate teaching schools right now are writing this down. They're going to start using this in class. So.
Okay, great. All right, all those in favor?
Aye.
All those opposed? Motion carries unanimously. Diane, number 2.
I just have a question for clarification on the summary. So in the postcard, did the respondent say they were licensed?
No.
Oh. Oh. So if we have to disclose if we do the business. I never thought about disclosing it when we're trying to do business. I mean, that was that was soliciting real estate.
Yes. For the respondent's investment firm.
But I always have the license tattooed on my forehead, right? I mean, I can separate myself from my license.
I believe there is. I'm sorry. I'm double checking the postcard right now to make sure that they don't.
Right.
Right.
No, there's no mention of them being a licensee on the postcard. I do think that if this transaction, if the seller or the property owner did decide to engage this offer, I do believe that they would have to disclose that they are a licensee, but
So
I don't
I
believe
can-
it's required on the advertisement itself or the solicitation to purchase.
If I can run an ad in a newspaper
If you
And-
buy a home,
to something, what I always called a blind ad, and said, call me at this number.
It's a solicitation.
Yeah. See, that's what I look at this as, is the same thing. I look at this as a blind ad, and I thought we couldn't do that. So I'm trying
I don't
to
know that it was a
learn.
blind ad, because a blind ad, I would refer to that as somebody you don't even know who you're talking to. But this one, it was an investment company, and it was the investment company that's trying to buy it, not the
Right.
licensee. And the investment company could be all owned by the licensee, but it could be multiple people.
All right, so
It's a
on,
separate
it
entity.
didn't have the licensee's name on it or the licensee's phone number.
no. Well, it has a phone number. It is not the firm's phone number.
Is the licensee's phone number?
Or excuse, it's not, to clarify, it's not the real estate firm where the licensee works. It's not the firm's phone number. It's the investment company's phone number.
But not the agent's phone number.
As far as I know, no, it's not.
Does that agent work at that investment company?
Yes.
Yesterday I received a phone call, and it was so funny. I was at my daughter's house, who's also a realtor, and it went on speaker. And it was someone interested in, so they had someone interested in buying my home, and would I be interested in selling my home? And I asked, oh, are you a real estate licensee? And when the minute I said that, they hung up. So there's a lot of fishing going on.
It says 2 or 3 groups are doing things that I know are illegal.
Well, we have it on TV, radio, everywhere now.
Okay, so I'm all right with this if it didn't give that. So how did it get connected to this licensee if it didn't have it on the postcard?
Or is it unlicensed activity by the investment company?
Well, at this point, the investment company is just trying to buy properties. And it's never illegal or unlicensed
About
activity if you're just
purchase.
buying.
Yeah.
Now, if you are brokering on behalf of the buyer, then yes, you have to have a license. But in this case, the individual does have a license. It's the investment company that's buying the property, and they're not linked to the licensee's real estate firm.
So what triggered this anonymous complaint to be connected to this licensee then?
Get those sorts of complaints all the time.
Oh, okay.
Oftentimes, I
The
assume
complainant knew.
that the complainant is a licensee. I couldn't say that's the case
So
here
you
for
didn't
sure.
see anything on the postcard that connected it to this licensee?
No.
Okay, then I'm okay.
So the second sentence says, the complaint itself was submitted without any context and contains only a postcard advertisement from respondent, a licensed affiliate broker. So did the postcard say that it was from the respondent?
It doesn't identify the respondent as a licensee. Let me
Does
pull
it
it
say
back
it's
up.
from Diane Hills?
No.
I mean, really?
I mean, does it say, yeah,
a name?
So there was a
John
complaint, but they
Smith.
didn't give you the postcard?
It just has their first name. Just I can't tell you what it is, but just
Like
John.
John.
Yeah,
It's just-
Did the complainant give you the postcard, though, or did the respondent give you the
the
postcard?
complainant did.
Okay, so then.
So it says investment company is interested in your property, and then it has a signature from a person's name, but not their whole name even, just the first name of a person.
Yes.
Okay.
And the only contact is the phone number.
There's a phone number and a website for the company.
The investment company.
Yes.
And we don't know that the phone number, who that is for.
No, I didn't call the number or verify.
Let's
who
just call it
belongs
right. No.
I already thought of that. Okay, if you're comfortable with it, that's my concern. I do think that even
It was a little
the
fuzzy.
first that name, and I don't know where the phone number goes, is sort of a blind aid.
Your earlier point, though, if this person did give this, number a call and they did speak with the respondent would have to tell them that they are a licensee if it went forward.
Move to dismiss.
Second.
Any other further discussion? All right, all those in favor of the motion, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 9, Bobby.
My question, I think this one was about the complainant saying that the respondent maybe tricked them into signing a buyer's agreement. On the confirmation of agency, was that included in what was checked there?
So there was to my knowledge, there was no confirmation of agency status. There's just the exclusive representation agreement. And I think that there wouldn't have been a confirmation of agency, at least not one required from the respondent's point of view, because the respondent thought, well, we've got an exclusive representation agreement, and there was no unrepresented party.
But didn't they wrote an offer, didn't they? Wrote a contract?
They did write an offer, but at that point, both the buyer and the seller were represented. So I have noticed that it's pretty routine to include those confirmation of agency status forms.
If there's someone on the other side, then the confirmation, you're giving notice to the other side, hey, this is how I'm representing these people.
Right.
I'm either I am or I'm not, and I'm just trying to make sure the confirmation, I mean, for the complainant to say they tricked me into signing this, if they tricked them, they had to trick them twice.
Right.
And so that's what I'm trying to find out. Did they really trick them twice, or?
Nobody mentioned the confirmation of agency status, and when I received your question via email, I did pull up a TR form to make sure that they weren't skipping over anything by not including that. I don't think that they violated any rules by not having a confirmation of agency, but yes, you're right. If there had been one, it would have been that they tricked them twice.
I think they needed to have a confirmation of agency. Because didn't this reach didn't they buy this property?
Not with the respondent.
Okay.
They ultimately did purchase a property on their own, and
Okay.
that sort of was the basis of this whole thing. That's when the respondent reached out to them and said, hey, wait a minute, what about this exclusive representation agreement that you just violated?
I'd like to pull this one out if we can and just see if you can ask for the confirmation of agency form.
Okay.
Do I make that in a motion, or was that a motion that I just did?
Second.
That was a motion then. Okay.
All right, we have a motion by Mr. Wood and a second by Ms. Hills that we pull that one out. All those in favor?
Aye.
All those opposed? Is that confirmation of agency something we can get today, or?
I would say likely not.
The one attorney here doing all this. Right.
I mean, I can request it today, but the odds of receiving it today would be slim.
Okay.
Okay.
Okay. All right. We'll move on. Bobby, number 13.
This one I was confused, I guess, about the response. This was I'm in the third paragraph. At the end of the third paragraph, and then it says, as such, they inform complainant that if they wanted to make an offer, there would be no buyer representation agreement involved, and the affiliate would no longer act as the seller's agent, it would only facilitate the transaction. So, did that make sense to you? I mean, what they said?
Yes. So the affiliate broker listed the property. The seller of the property didn't really know anything about it. They didn't want any negotiations. They just wanted it sold.
Okay.
So they said, all right, I'll list it. If somebody wants to put in an offer at that point, I'm going to be a facilitator. I'm not going to represent either side. And that's actually a default status under our statute, that you default to facilitator if you are representing both sides. absent a written agreement otherwise. But they had a written agreement that said they were going to act as the facilitator only.
They had a written agreement said they were going to be a facilitator. But if they did a listing agreement, that the listing agreement probably says I'm going to represent the seller.
Well, honestly, I don't even know if there was a listing agreement. I know they had permission to list the property. If they had executed a written agreement with the seller, I'm not sure. But if they had, at that point, all parties had agreed, or at least the seller and respondent had agreed that they would no longer be their agents.
So this seller just threw it out there, and if anything stuck, and so this agent's like, oh, I got a buyer. And so I guess that makes it really easy for the licensee, doesn't it? Not represent anyone.
Right.
But I guess they have that legal right,
Well,
especially if
But-
that's the way the seller wants it.
Well, there's this another thing in here too that
Yeah.
concerned me, because I get two more paragraphs down, and then there were I think this is when they ask them to go out and take pictures, and then they come back and say something to the effect of, but ultimately told them that the affiliate broker was a facilitator, and that they were not obligated to go back out to the property because they're a facilitator. I'm just not convinced that these people understand what agency is.
Well, they weren't an agent in this. They were definitively not an agent in this situation.
if they had a listing agreement, it says you're going to be loyal to your client. And my understanding of the way to get rid of that is have another written agreement saying we're canceling that.
Right.
You're right. I wake up in the morning and I'm a facilitator. I look in the mirror, I'm a facilitator. Because I don't have a listing agreement. I mean, I don't have an agreement with someone. So to me, you have to kill the listing part. But if you don't have the listing agreement, we don't know if that's what it said.
And just because a buyer is unrepresented doesn't mean you have to be a facilitator. You can still represent the seller and sell the property.
Yes, they could have, but for whatever reason, the respondent
It
opted
wouldn't
to.
be responsible.
Right. And I mean, like I said, there was a written agreement, the confirmation. In this case, there was a confirmation of agency status. And it had the licensee clearly designated as a facilitator. And the form also explains what a facilitator is, that they're not an agent.
But the confirmation doesn't release
The listing
the
agreement.
agency agreement.
Yeah.
And it doesn't stand, it just shows we're a facilitator. So I guess my question is, did it ever get, oh no, without seeing it?
I don't know. The more I ask questions, the more questions I have on this one. Okay, would this just be completely out of line? How about if I think this is just one I'd like to see more of. And is this? Would y'all be comfortable with letting me look at this one, and then I'll come back and talk about it next meeting?
Motion to have Bobby Woods review number 13.
Second.
All right, any other comments? Pay attention to that the complaint is against the firm
Okay.
and not a person.
Okay.
too.
Good point.
All right, so all those in favor?
Aye.
Those opposed? Motion carries unanimously. Okay,
Will we repeat who made and seconded the motion?
I made it.
Okay.
Second.
All right, number 15, Bobby.
Or was that mine?
Yep. I think it was me.
Bobby's.
On 15, my question was, let's see. We were going to dismiss, I think these people, it was a unlicensed property management company. And then this was a complaint filed. My question is, was the complaint filed before or after their license got revoked?
It was filed before the license was revoked.
They didn't respond before they got their license revoked. It said they didn't submit an answer.
Okay.
So will this go in their file when we dismiss it? If
Well, it'll come out of the file. I mean, if it's dismissed.
I could change my recommendation to a close and flag to make sure that it is pinned.
Yeah, I don't know if this person will ever come back, if they can challenge or being revoked.
If
or where
they
are.
did, they would have to have an informal appearance, and the odds are no, they would not.
I think we should close and flag it, though, just so that it doesn't slip through the.
Okay.
You know.
Motion to close and flag.
Second.
All right, any other discussion? All right, we have a motion by Ms. Hills, seconded by Mr. Woods. All those in favor of the motion, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 17, Bobby.
If I remember right, I think this was because I made myself a note about. I think there was just two completely different responses, and so we kind of come to a draw. And then, if I remember right, and it had to do with how the buyer or something, and I didn't know if it would be proper for us to reach out to the buyer and say what really happened here, because they would be the one that would have the answer.
I think that is an option we could take.
Of course, they could always say or not respond. They don't have to respond to us, but
I didn't feel it necessary to contact the buyer because both the complainant and respondent stated that the buyer approached respondent.
Okay.
So having that, especially having the complainant say that my client went to them,
okay.
I figured they're probably telling the truth because
Okay.
that certainly doesn't help their case.
Okay. All right. I agree with that. Make the motion to accept council's recommendation to dismiss.
Second.
All right, we have a motion by Mr. Woods, a second by Mr. Diaz. All those in favor, vote aye.
Aye.
All those opposed, motion carries unanimously. All right, I was number 20. Okay, so this one involved an unlicensed team member. And I just wondered, does the action of this team member, should they have been licensed or not? I'm trying to remember now.
It's just an ongoing problem
So
with the team.
the team members are all licensed, but the team hired an employee to help manage their business. And when they hired the employee, I guess because they started taking care of the administrative measures, this email that made all these claims about, I'm dedicated, I want to represent you, started coming from the employee's email address, but they never changed the context of the email. So the principal broker here is saying, I didn't know this happened. Once we figured it out, we sat down, we changed the email marketing campaign. It's no longer coming from the employee. And they also had the team members and the employees submit affidavits swearing that the employee wasn't trying to be a broker or hold themselves out as one. It was just an administrative error.
So, but it's, they're saying they were guilty. In other words, the principal broker says they were guilty.
I think that
That's like my husband always wants to get forgiven, not get permission deal to me.
the principal broker was aware of the email in its original form. I don't honestly think the team members even realized that this email is now coming from the wrong email address.
Whose responsibility was it, though?
Well, ultimately, the principal broker has to approve all advertisements. I think in this case they did. It's just the manner in which the advertisement was communicated that there was a little, there was just a mistake there.
So probably the licensee said to the non-licensed person, send this email. And so this person just sent it on hers instead of, and so I would think that other agent, the licensee, would have been copied, you would think, or there would be something in place. If I had someone unlicensed send an email on my behalf, I would want to be copied on it to make sure that there was no problem with it. I just think this was very sloppy, and it's just like, you know, they're saying they're guilty. I guess it goes down to, you know, it's black and white in my mind, but maybe not everybody else's.
Oh, and I mean, and we get them, and I think this is a good example, like Commissioner Wood says. We get them from employees saying, our seller is countering at this, our buyer is countering at this, and I'm thinking, and who are you? You're not a licensed person, and the way it's worded, it would, you know, appear, and that is a downfall to the setup and management.
So I would like to make a motion that we send a letter of warning to. Does it need to go to the principal broker and the affiliate, or just the principal broker? It's actually, the complaint is against a real estate firm.
It would,
So,
in essence, go to the principal broker.
Principal broker then. I'd just like a letter of warning to the principal broker.
Second.
So there'd be something in the file. Okay, so, all right, so we have a motion by myself and a second by Mr. Diaz. Any other discussion? All those in favor, say aye.
Aye.
All those opposed, motion carries unanimously. Number 32, Bobby.
$32 was the vacation lodging, and that they were doing vacation lodging, and then I guess it was pointed out that they were not licensed, and now they've come back and said, and maybe they were in the or they've got their license now, and I was just, so they basically got caught, and then now we're saying, okay, well, now you got your license, we're good. Why didn't we give them a civil penalty? That's just kind of
I wrote this complaint, and
Okay.
I went back and forth with what to do with it. I thought since that they were licensed now, we could maybe dismiss it, but then I also thought maybe sending out a letter of warning or a letter of instruction about doing these kinds of instances to prevent it from the future. But basically, I was the same place that you are about what to do.
I think we need to do something.
how many of these properties were they handling?
I know that there are a couple properties that they were managing, and then there were some that they owned, some that they did not own. And there was an article in the newspaper about this company, which is how the complaint ended up coming to us in the first place. And so there were, I can't remember the exact number of properties, but I think I can find out how many there were.
And this person was first licensed March of this year.
Right, so in the process.
But it was open in February.
Yes, so they filed, made an application to get licensed after the complaint was filed.
That don't jig with me either.
And they had an attorney that responded and said something that says, by their limited knowledge and understanding of the actively evolving area of law regarding short-term. So basically, excuse them, they didn't know.
Forgiveness, not permission.
Yeah.
Would you like to make a motion, Mr. Wood?
Yeah, I'm going to say I'm appreciative that they got licensed, but, I shouldn't be appreciative. They were legally supposed to do it in the first place. I almost get the feeling they were more apologetic because they got caught, not because they did something wrong. Yeah. Marcia, you make comment about that, but that's in the husband's manual. When we get married, we're taught that, so I just want you to know.
By your daddy.
I'm going to say make a motion of $1,000 civil penalty for unlicensed activity.
Second.
Any other discussion? We have a motion by Mr. Wood, seconded by Mr. Diaz, for a $1,000 penalty. Is there any education that that you deem necessary, or is just a?
I think just a civil penalty. I mean, because I'm sitting here debating, what if they were doing 7? Good night, that could be
No.
7 times that. So
This is easy on.
I think this is they may not feel lucky, but I think this is fortunate for them.
Okay. All those in favor of the motion, vote aye.
Aye.
All those against, motion carries unanimously. Number 40, Diane.
So, I guess, does the address for this principal broker, is this a correct address? I mean, we work so hard for this, but when you list your property and that seller ought to be able to find the broker. Let's see. So they called, text, and emailed several times with no response. And they got and after they filed a complaint, that's when they got the release. So I guess my question is, did they say that nobody would return their call or something, or did they have the wrong place?
I am pulling up.
Oh, the release went to the says the request to be released. A respondent says it was going to the wrong address. So, yeah, that's where it is.
So do we have any mechanism if people are not giving us their right addresses? They're required to. I mean, is there not some way that we can make these people see that it's important that we have it? Because we get it every month. People are like, I didn't get my mail, you know.
This is not us. This is the complainant saying they didn't have their address, isn't it? So this is really, that has nothing to do with our office.
The respondent said that the request had gone to the wrong address. So the respondent had it listed.
Right.
And who they're working for doesn't have their address.
Yeah.
So
So
they
their
can't
principal
find
broker doesn't have their address?
Yeah, they can't find it.
Something wrong with that picture.
This is why I thought dismissal was okay, because the complainant, I think, made the assumption just because they said they wanted out of the listing, they get out. But that's not how it works.
Well, but they requested to be released, but
Yeah.
never got it, never received the
Well, that's right, because the
formal release.
listing company may not have wanted to release them.
Yeah.
Because it never said
don't
they
have
agreed to
They're
it.
not required to
But,
release it.
but the respondent said, well, we couldn't release them because it was sent to the wrong address. That's what the response says. The request to be released, we're going to the wrong address.
So did that release, you have a copy of that release? They sent them to the wrong address?
No, the complainant didn't provide any, evidence.
Or if
of
the
anything.
respondent was sending it to the wrong address?
But the complainant did provide what they thought was the respondent's address, and it's not the respondent's address. I don't know where they got it from, but
they didn't provide. They didn't provide because the respondent's saying we try to get back in touch with them, right?
No.
But they couldn't.
No. Respondent saying that the complainant sent it to the wrong address.
Oh.
Yeah.
Oh.
That's how I'm reading it.
Okay.
Right, and the complainant said we texted and emailed, but they didn't have any documentation of those emails or those text messages.
Oh, okay. No proof.
Yeah.
No proof. Okay.
Right.
So the respondent may need to ensure they have the correct mailing address and email address for themselves.
And I looked in Core, and their address is current in Core. So I think the complainant was confused.
Now, usually a real estate company wants to make sure you can get in touch with them.
Yeah.
Right.
Well, unless it's one that's beyond the 50-mile rule. Motion to approve.
All right, we have a motion to approve
To prove the dismiss, is that what?
to dismissal by Diane and a second by Mr. Woods. Any other discussion? All those in favor, vote aye. Aye. All those against, motion carries unanimously. All right, that completes our consent agenda. Do you need to get some water or something? You got some?
Thank you, sorry.
All right, so next on the agenda. Our legal report. Where's my agenda? It's that biscuit.
No, I mean,
Okay.
that may work.
All right, so are we prepared to begin the legal report now?
Do we take just a quick break?
Sure.
No more than 5 minutes?
5-minute break. You got it.
Thank you.
Two girls, what did it say?
It says, and why am I not surprised?
Probably Rihanna.
No. And the meeting, they're going to have to contact
Yeah,
them.
Rihanna, why am I not surprised? Okay, we're going to get going again, everyone. We're ready for the legal report.
Number 1 on the legal report is 2019-004391. Complainant is a timeshare owner and respondent operates a registered timeshare resort. Complainant alleges respondent's sales agents willfully ignored their request not to make any sales pitches to their spouse, who was staying at the resort on their own and who had recently been diagnosed with bipolar manic depression. Complainant states that nevertheless, their spouse attended a members update where one of the agents tried to get the spouse to upgrade their timeshare interest. Complainant states the agent called them during the sales pitch and they told them they weren't interested, but a few months later, complainant states they received their first bill for the upgrade. Notice that the complaint was delivered to the address provided by respondent on or about January 24th, 2019. The complaint was also sent via email on January 16th. Respondent did not provide an answer to the complaint. My recommendation is for a $1,000 civil penalty for failure to respond to the complaint within 10 days in violation of Tennessee Code 62-13-313.
Motion to accept council's recommendation.
Second?
All right, we have a motion by Ms. Hills and a second by Ms. Taylor. Any discussion?
They have to respond. Isn't there somebody in timeshare that doesn't have to respond to us?
I would have to review the statute. I don't know that there's anyone that doesn't have to, aside from non-licensed individuals.
Okay, I'm ready.
All right, all those in favor of that motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 2.
Number 2 is 2019-006121. Complainant was the property buyer and respondent was the listing agent. Respondent is also married to the property seller. Complainant alleges respondent failed to disclose known adverse facts about the property. Complainant alleges that respondent was aware that the property has serious flooding issues whenever there is a heavy rainstorm and that respondent withheld this information from complainant. Complainant states the property has flooded 4 times since they purchased it in July of 2018. Respondent states that their client purchased the property in 2016 from Housing and Urban Development. According to respondent, there was no issue with flooding at that time. Later in 2017, respondent states that there was some water intrusion caused by bad weather, but the problem was corrected with the installation of a sump pump. Respondent also states that the property was briefly rented to a family of 5 in 2018 and there were no complaints about flooding or other similar issues. According to respondent, they discussed the sump pump and how it had corrected past water issues with complainant when they viewed the property. Respondent also notes that there was a home inspection and that there was plenty of rain in between contracting for the sale and the closing and that there were no issues during this time. Based upon documentation provided by respondent, it appears that respondent's spouse was the authorized agent and signatory for the seller, an incorporated investment firm. Respondent provided a copy of a personal interest disclosure form, but it was only signed by the spouse, not by complainant. It is unclear if complainant ever signed the disclosure. Respondent also provided a copy of the purchase and sale agreement, which states the home was to be sold as is, a copy of the home inspection report, which states that the sump pump was inspected but provides no further detail, and a residential property condition exemption notification, which again was signed by the seller but not by complainant. Section 403(2) of the Broker License Act requires licensees to disclose to each party to the transaction any adverse facts of which the licensee has actual notice or knowledge. And Section 403(7)A prohibits licensees from engaging in self-dealing or from acting on behalf of the licensee's immediate family or any other individual, organization, or business entity in which the licensee has a personal interest without prior disclosure of the interest and the timely written consent of all parties to the transaction. Council does not believe the evidence clearly shows that respondent failed to disclose there were water intrusion issues, but recommends disciplinary action based upon the lack of written consent to respondent's personal interest. My recommendation is for a $500 civil penalty.
Motion to accept council's recommendation.
All right, we have a motion by Ms. Hills and a second by Ms. Taylor. I guess I am wondering, how could they not have known? Is there an exclusion because they didn't? Was there an exclusion that they didn't live there or something? Or how could they not have known if it has flooded 4 times since the closing?
That I couldn't answer for you. The respondent states that there were no issues aside from, some minor water intrusion that they state was corrected by the sump pump.
So they said they fixed it.
They said they fixed it, that they discussed it with the complainant when the complainant viewed the property. I think we should also keep in mind that a lot of times when complainants say, my property flooded, I think there may be different understandings of the term flooded. I don't know how significant the damage was. This respondent saying there's water
Complainant
intrusion.
didn't provide any
Complainant says
proof
it's
that it flooded. I mean,
Mm-hmm.
so they just made an accusation on that part of it.
One thing, there are things that are flooded. They haven't flooded before.
There's been a lot of flooding.
Yeah, there's been a lot of flooding, unusual. But I think they did everything they needed to do myself.
Any other discussion? All those in favor of the motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 3.
Number 3 is 2019-006071. Complainant is a timeshare owner. Respondent was a timeshare salesperson and supervisor, and respondent is not licensed. Complainant states that while staying at a timeshare resort in 2017, they agreed to attend a members update meeting with the resort sales representatives. Complainant says the sales rep informed them that they needed to purchase an upgrade because their points had become obsolete after the timeshare company revised its program a few years back. Complainant states the rep pressured them to upgrade, but they refused. Finally, they asked if complainant would speak with their supervisor, respondent, and complainant agreed. Complainant alleges respondent offered to buy complainant's timeshare for $30,000, but only if complainant transferred their points to a different program. Respondent stated the process could take as long as 90 days and they would receive a check in the mail. Complainant states they asked about the legality of the transaction and respondent told them not to worry. Complainant states they were also advised not to disclose the transaction to any other representatives when they called to transfer and upgrade their points. Eventually, complainant lost contact with respondent and learned in December that both employees were terminated by the timeshare company. Respondent failed to provide an answer to the complaint. Counsel recommends the commission authorize disciplinary action for unlicensed activity. My recommendation is for a $1,000 civil penalty.
So I can talk about motion to accept council's recommendation. So who are we fining?
The supervisor / sales representative who was not licensed and, was pressuring the complainant to upgrade or transfer, but also to sell their timeshare. I think that there are significant legal issues here, but within the commission's jurisdiction, it looks like unlicensed activity.
So this was opened against somebody who's not working there now, right?
Right.
So, and that's not who we're finding. We're finding the company supervisor.
No, it's the individual, the unlicensed agent. that no
What
longer
about
works
the
there.
firm? I mean, doesn't the firm have some responsibility for having unlicensed people working for them?
Yeah, somebody licensed.
We could open a complaint against the timeshare company. In this case, it is only against the individual.
Know where those two people went? Did they go to another company, or they just disappeared?
At this point, we don't know where they are.
Yeah.
Okay, so the motion at this point is $1,000 civil penalty for unlicensed activity.
Offer a friendly amendment to open an administrative complaint against the firm.
Second.
Right, any other discussion? All those in favor of the motion signify by saying aye.
Aye.
All those opposed? Motion carries unanimously. Number 4.
Number 4 is 2019-005451. Complainant is the owner of a rental property, and respondent is a licensed real estate firm that provides property management services. Complainant alleges respondent failed to screen tenants who leased complainant's property, and that the individual responsible for the management of complainant's property is unlicensed. Complainant alleges that their property manager failed to screen applicants and secured quote-unquote undesirable tenants who left complainant's property with thousands in damages and unpaid rent.
Did they ever mention what they meant by undesirable? Were they referring to Donald Trump supporters, or what were they doing there?
They did not.
So-
They didn't provide
Couldn't
any
have been.
details. They just
Okay.
say that the property was damaged, but they didn't say why these people were
Undesirables, okay.
Right. Complainant alleges that this was a direct result of respondent's failure to screen the tenants. Complainant further alleges that the property manager only had one of the 3 co-tenants sign the lease. And complainant states that the property manager's actions do not conform with respondent's website, which claims to provide professional, trustworthy property management services from tenant screening to leasing to maintenance and evictions. The individual property manager provided an answer to the complaint. The property manager states that they screened the tenants and that they met all of the firm's requirements for renting one of their managed properties, including income, verified rental history, no felony convictions, no open bankruptcy proceedings, and no evictions. According to the property manager, the tenants left the house in a mess, and there was some minor damage to a retaining wall, but nothing that could cost thousands of dollars. Complainant asked respondent to hold on to the security deposit until they received cleaning and repair estimates, but never sent over the estimates. Sometime thereafter, an attorney for complainant asked respondent to return the security deposit to complainant in full, and they did. Counsel notes that the individual property manager was previously licensed as an affiliate broker, but that their license expired in 2011. Respondent, the firm, is managed by a licensed principal broker. Tennessee Code annotated 6213-104 exempts from the licensure requirements the employee of a broker who manages an apartment building, duplex, or residential complex where the person's duties are limited to supervision, exhibition of residential units, leasing or collection of security deposits, and rentals from the property. This exemption does not include anyone who negotiates the amounts of security deposits or rentals or negotiates a lease on behalf of the broker. In the present case, the property manager is employed by a licensed broker, but they are engaged in the management of a single-family residence. Thus, under a plain reading of the law, it would appear they do not qualify for the exemption from the license requirement. The complaint was opened against the firm, therefore counsel recommends it be dismissed. However, counsel does recommend that disciplinary action be taken against the property manager for unlicensed activity.
Would you accept counsel's recommendation?
Is there a second?
Second.
I would just add, I don't really know how the commission goes about doing that without just opening the complaint against this individual. Even though I know we have all the facts here, and that's kind of a pain that we'd have to restart the process. But I do recommend that action be taken against this individual. And if that means we have to open a new complaint, then that would be my recommendation.
Would you like to amend your motion, Mr. Diaz? So it would be a complaint against the...
Unlicensed activity, maybe we should look back at the firm.
So my question is, why isn't the firm responsible for hiring unlicensed
that's-
people? I mean,
The principal broker, at least.
Yeah,
I think the firm has some problem here.
yeah, I'm going back to the firm now. I'm thinking, yeah.
I think they're all in trouble.
Oh, that's,
I mean,
But here's the other thing too, is if it goes against the firm, that's one thing. If the principal broker though has another problem over here, it's not going to be on their record. It's going to be on the firm's record. I like seeing if there's a principal broker has made a mistake, that it's on there, so for future reference.
So would a failure to properly supervise be appropriate for the principal broker, or is there some other?
Well, this
Well, there's
is the firm.
unlicensed activity.
So, because this is just the firm right now.
Yeah.
So then we would have to open one against the broker if you wanted to do that. And then open one against the unlicensed person if you want to do that. So,
Right, so there's two.
I mean, so really that makes 3 cases. This is just one of the 3. So, maybe the thing is we might want to, okay, this is what I would like to offer a substitute motion that we offer for a civil penalty to the firm for $1,000 for having unlicensed people there in their office doing the activities that licensees should have, but then also open a complaint against the broker and the unlicensed person for unlicensed activity.
Is there a second?
So for the broker, for failure to supervise, or
Well, do we have anything that says you're only supposed to have licensed people at your office doing I'm good with failure to
Doing activities
supervise.
of a licensee.
Yeah.
I just think for like the principal broker, it would be probably failure to supervise.
I'm fine with that.
I'm
fine with that.
But I mean,
It accomplishes the same
We
thing.
would just open the complaint and then
Okay.
go from there. Okay.
Okay, I'm fine with that.
And then we'll hear that and decide on that one.
I'll second it.
That is a thought. I mean, there's not a rule about a broker that hires somebody that's unlicensed to do their thing. I mean,
Ought to be a rule, right? Or
yeah,
something.
it ought to be a rule.
There is a firm requirement, an office requirement that a principal broker has to ensure that the licensees,
License.
that the licenses are hanging and on display in the office. So I think that's sort of a roundabout way of saying you got to make sure everybody here has a license.
And I have been seeing more and more and more people are keeping their large firms are keeping their licenses in their drawers.
I don't see
You don't want to do that.
The statute does say prominently
Displayed.
on display.
Okay, so I have a motion by Mr. Wood. Do you want to repeat that?
No,
Okay.
but I will.
So I think I want to make sure that I
Yeah.
have it right.
Yeah.
So a civil penalty to the firm for $1,000 for having unlicensed individuals working, and opening 2 administrative complaints, one against the principal broker and one against the unlicensed individual.
Right.
Is that correct? Okay. Do we have a second?
Ms. Taylor?
Okay.
Okay, are we ready to vote? All those in favor of the motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 5.
Number 5 is 2019-006471. This is an administrative complaint opened following a random audit of respondents' accounts and records. The audit was opened in May 2018. Standard documents and firm records were requested via letter dated May 11th, 2018, with a response deadline of June 8th. Respondent's principal broker provided some of the requested records, but advised that they were unable to provide bank statements and reconciliations for the firm's escrow account because all earnest money funds received by respondent, a branch office, are deposited in the main office's escrow account. Several subsequent requests for the bank statements were made, but the principal broker didn't provide the records until the present complaint was filed. Upon receipt of the records, Auditor Michelle Fenn found 2 instances in which earnest money was deposited 5 days past the payment deadline in the purchase and sale agreement, and 1 instance in which the deposit was delayed by 1 day. Tennessee Code Annotated 6213-321 provides that every broker shall keep an escrow or trustee account of funds deposited with the broker relating to a real estate transaction. However, Tennessee Comprehensive Rules and Regulations 1260.02-.096 also states that where a contract authorizes an individual or entity other than the principal broker to hold trust money, the principal broker will be relieved of responsibility for the trust money upon receipt of the trust money by the specified escrow agent. License records for a respondent indicate the firm does maintain an escrow account, although it doesn't appear that the account is utilized, and the purchase and sale agreements provided by respondent all designate the main office as the holder of the earnest money funds. Therefore, it appears the issues are limited to the delayed deposits noted in the audit and the repeated request to obtain the records themselves. Council recommends a $500 civil penalty for respondents' failure to produce the records when originally requested, with the language in the consent order also addressing the delayed earnest money deposits. And to reiterate, my recommendation is a consent order finding both violations, but only with a $500 civil penalty for the violation of 6213-312. And then I'll just add.
Yeah, what? Can you start right there? So is it 312 or is it 321?
It's 321.
Okay.
Sorry, that was
It's okay.
a typo.
It's okay.
But I just wanted to add, the reason why I'm only recommending a civil penalty for one of these violations is because if it were limited to just the delays, 5 days, that's not great, but I would have recommended a letter of warning for that.
But you're saying $500 because there's a 5 and a 1 day? Is that what it was?
No, $500 because the commission staff had to request these records from the firm numerous times, and the statute is very clear that commission has the authority to review those records and that they have to maintain them and provide them to commission staff.
And did they ever really provide them?
They did. They did provide them, and that's where the findings of the delayed deposits came from.
Okay.
So they do have an escrow account. They have not applied for a waiver for that location.
They do have an escrow account.
But they just choose not to use that one. They're using one of the other location.
Right.
Okay.
And I'm seeing that more and more and more and more. Companies not wanting to hold the money themselves.
Yeah. But
Because of
you
the
have
responsibility of it. And so give it to any lawyer, or it could go to any escrow account anywhere, I guess.
Well, I think, excuse me.
I was going to make my motion would be, my first thought was, I was like, well, for just the 5 days and the 1 day, that seems awful harsh. But if you have to keep going back and asking for it, that does give me some concern. And so for that reason, I would agree with let's do the recommendation of the $500 civil penalty. But in addition to that, can we also issue a letter of warning? But can you give them both things?
Instruction.
Or a letter of instruction.
Yeah, instruction.
And the letter of instruction but saying two things. One, let's make sure our contracts match as far as number of days, what you actually do in your earnest money. But the other thing is, too, where I thought when I first was reading this, I thought the issue was going to be the fact that maybe, you can hold your earnest money anywhere. Just make sure your contract matches where you hold your earnest money. And I got a little indication that maybe they were saying the earnest money is being held by our local office, but in effect it was being held by the main company somewhere else. And so just make sure those match in their letter of instruction.
And it needs to not say main office. It needs to say the name of the office and the address. Everything that's required.
That was my editing. I realized I did put main office in quotes. It wasn't a direct quote from the contract. I was just saying the main office.
So they did have the correct name and address. Okay.
My thought was because we had to keep asking them for the things that it ought to be more than the $500. That's my thought. Why would you have to keep asking somebody for information when they've been audited? All right, well, I would make it $1,000 because they had to ask them at least twice, right?
Well, I made a motion and I didn't get a second.
Yeah, there's not a second.
Might be ready to have another one then.
Well, I'll make the motion that they $1,000 for that same code, but you had something else in there, right?
The letter of instruction.
In the letter of instruction. All right. We'll combine it. Is that okay?
Would somebody like to second it? We'll see if it's
I'll second
it. Okay.
Wood, you said there were two things you wanted in the letter of instruction.
Yes.
So it was for the contracts to match who's holding the earnest money, and what was the second thing?
And the other one was to make sure that whatever number of days they put on the contract, that the earnest money had to be turned in by, that's exactly what they went by. Or they had paperwork to show that had been changed.
Extended.
Yeah.
Okay.
Thank you.
Any more discussion? All right, let's vote. All those in favor, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 6.
Okay, number 6 is 2019-009101. Complainant is an elderly timeshare owner and respondent is a timeshare company. On July, also, I'll just add, this one is a dismissal, sorry. This one is a dismissal, but it is relevant to the one below, so I'll still read it in the record. Okay. Complainant is an elderly timeshare owner and respondent is a timeshare company. On July 20th.
Would it bother you if I move to dismiss?
No, it doesn't.
Okay. Move for dismissal.
Is there a second? Okay. Any discussion? We have a motion to dismiss by Mr. Woods and a second by Ms. Hills. All those in favor?
Aye.
All those opposed? Motion carries unanimously. Number 7.
Okay, 7 is 2019-008781. Complainant is the timeshare owner from the above related complaint. Respondent is one of the salespersons complainant interacted with when they made their 2018 purchase. Notice of the complaint was sent to respondent's business address and respondent's home address. Respondent failed to submit an answer to the complaint. Recommendation is for a $1,000 civil penalty for failing to provide an answer to the complaint.
Motion to accept council's recommendation.
All right. Any discussion? We have a motion by Ms. Hill, seconded by Ms. Taylor. All those in favor?
Aye.
All those opposed? Motion carries unanimously. Number 8.
Number 8, 2019-008811. Complainant, again, is the timeshare owner from the 2 above related complaints. Respondent is the second salesperson complainant interacted with when they made their 2018 purchase. Notice of the complaint was sent to respondent's business address and respondent's home address, and respondent failed to submit an answer. Again, my recommendation is for a $1,000 civil penalty.
Motion to accept council's recommendation.
Second.
All right. We have a motion by Ms. Hills and a second by Mr. Diaz. Any discussion? All those in favor, vote aye.
Aye.
All those opposed? Motion carries unanimously. Number 9.
Number 9 is 2019-004111. Anonymous complainant alleges unlicensed activity. Respondent is a vacation lodging service not presently licensed with the Commission. Respondent began renting their own property in 2011 and over the years expanded their available rentals to include 1 more owned by Respondent and roughly 8 other properties owned by friends of Respondent. Notice of the complaint did not reach Respondent until June 21st, 2019. Upon learning about the complaint, Respondent states they began the process of applying for their VLS license. Records do not yet show receipt of an application. Council recommends a consent order imposing a civil penalty for unlicensed activity if Respondent fails to obtain their license within the next 45 days. And again, that recommendation is for a consent order requiring Respondent to become licensed within 45 days or otherwise pay a civil penalty for unlicensed activity.
So it seems to me we have a theme of forgiveness going on here today. This looks like another one of those. We don't typically give someone 45 days, and a complaint's been filed. Now it's before us. Why do we give them 45 days to get licensed? And in fact, they haven't even made an application.
As of when I was drafting this response, that's true. I don't know where they are in those steps.
Doesn't really matter, though, does it?
Well, it is unlicensed.
She's just nicer than we are, Marcia. That's what it is.
More gracious.
I like to give people a second chance.
Well, it's not time for that. I mean,
Okay.
they got to become a licensee first before they can get Okay, so is there a motion?
And I put a little mark, why not pay now, on the side of mine.
I put no exclamation mark.
Well, let me see what I'm.
So it's unlicensed activity. We typically give $1,000.
And there's 8 offenses that we know of. You want to make a motion? Yeah, me too.
I'm thinking on that, then, well, we've already told them they needed a license, and they said they were going to apply, and they haven't, right?
Well, like I said, they didn't receive the complaint until June 21st, so just a few weeks ago. And that's because...
That's 6 weeks ago.
No. It was,
Oh, June 21st. I thought
Yeah.
you said first. Okay.
Like, what day is it?
So,
In my own world.
yeah, they didn't
been
receive
about
the
3
complaint
weeks.
until recently. They said they're going to
Almost 3
start
weeks.
the license process.
It doesn't matter.
It's still been 3 weeks, so, yeah, I agree.
Still haven't done
But
anything.
the thing
Doing
is,
business.
$8,000 would really get their attention.
It would probably put them out of the...
Out of what?
Well, no, I nothing. I won't add any more comments. We don't know their situation.
We know their situation is they're unlicensed.
We do know that.
Okay, that's what we know. And our situation is not to know how fluent or anything anybody else is. The fact is they didn't do this. And so if we're going to speak about leniency, we could say $4,000.
This has been going on since 2011.
Oh, okay, $8,000.
8 years.
$8,000 is what we. $8,000 is what we're doing because they're doing their unlicensed
it's
activity and
1,000 a
8
year.
times 8.
And listen, they've made more than $8,000, I would say, probably in this length of time. Is there a second to that motion?
And could you also add maybe a cease and desist also?
Okay.
And then did you get your
They
second?
must be licensed. For unlicensed activity, they're getting $8,000, right?
Right. And
then
cease
they
and
need
desist.
Cease and desist.
And we need a second for that motion.
Second.
Okay. Any discussion? We have a motion by Ms. Taylor for an $8,000 civil penalty and cease and desist order for unlicensed activity. A second by Ms. Hills. All those in favor of that motion, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 10.
Number 10 is 2019-001521. This complaint is against a fraudulent cloud company which purports to be in the business of timeshare relief. These individuals have been have been impersonating legitimate Tennessee brokers and oftentimes provide false addresses to make it appear that they are operating locally, but it is suspected that these entities, or possibly a single entity, could be operating outside of the United States. Council recommends this matter be referred to the Attorney General's office, where there is an active and ongoing investigation.
Move to accept council's recommendation.
Second.
All right, we have a motion by Mr. Wood, second by Mr. Diaz. Any discussion? All those in favor, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 11.
Number 11 is 2019-010291. Complainant and respondent are licensees. Complainant states that they were working on procuring a rental property for their client. Complainant alleges they spoke to respondent about the property because their client had credit issues. Complainant states respondent does not have a particular credit score required, but conducts an inquiry of how the score became, or conducts an inquiry of how the score became so
Low.
low. Yeah, okay. Sorry, I didn't.
That A's right there next to the O.
Okay. Complainant then states respondent inquired about complainant's client's race. Complainant explained they did not know but made a determination via social media. Complainant then alleges respondent stated they asked this question due to the type of neighborhood and did not want to waste their time if complainant and their client were going to show up because of the area. Complainant then states respondent attempted to clarify that it didn't matter what race their client was, but the history of the area made them ask. Respondent answered the complaint stating they do not recall asking complainant about their client's race. However, respondent does state that they may have mentioned the rental was located in a rapidly changing area. Respondent also mentions in their response they are well aware of the rules about redlining, steering, and normally tell prospective clients the area of the property in question has been given a bad reputation unnecessarily. Based upon complainant and respondent's responses, council recommends a letter of instruction advising respondent of the requirements set in Tennessee Code Annotated 6213-31213, which is
Violating any federal, state, or municipal law prohibiting discrimination in the sale or rental of real estate because of race, color, religion, sex, or national origin. I was looking you up.
and that recommendation is for a letter of instruction.
Hey, how do we feel about this one?
How about a class on fair housing laws?
I think that's exactly what I was thinking. About a 4-hour fair housing that they do not get CE for, and do it within 180 days. And I'll second what he said.
So that was a motion by Mr. Diaz and a second by Mr. Wood, or together.
We're just thinking alike today.
Between the two of us,
dual
just thinking alike.
There's a lot
It's a
that
dual motion. Okay, any discussion on that one?
We're a real estate commissioner team, is what we were on that transaction.
Oh,
so.
God, don't say that. All right, all those in favor of the motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 12.
12 is 2019-011981. Complainant is a Tennessee resident and respondent is an unlicensed Tennessee company. Complainant states after respondent showed them 2 homes, complainant went online to fill out an application and paid the application fee. Complainant then states that they received a text message from respondent stating they would approve the application, but first needed to pay a deposit and first month's rent. Complainant then stated respondent informed them that after the 2 decided on a move-in date, complainant would need to sign the lease. After reviewing the lease, complainant stated there were several provisions complainant would not agree to. Complainant then tried to contact respondent and was unable to, but spoke to an individual from respondent's office. Complainant then attempted to get their deposit and first month's rent back. Complainant alleges respondent informed complainant they would not return the money. Complainant states they could not find on respondent's website where the deposit and fees were non-refundable. Complainant has filed a police report and complaint with the Better Business Bureau. Respondent answered through their attorney. Respondent's attorney informed counsel they are not in the business of property management, but instead own a company that is in the business of flipping houses, and respondent's company is the name under which they title investment properties. Respondent's attorney states they did not own the property for which complainant placed a deposit. Respondent's attorney states that the complaint has been filed against the wrong business entity. Respondent's attorney also states complainant paid a holding deposit that secured the rental property for complainant and was subsequently removed from the market. Respondent's attorney concludes complainant's deposit was a non-refundable deposit, and Tennessee's laws are lenient towards landlords. Counsel concludes that the Commission does not have jurisdiction over landlord-tenant disputes. However, it is clear that the entity complainant dealt with is a property management company. Complainant provided receipts showing payment to the unlicensed property management company. Furthermore, respondent's attorney clarified the owner of respondent's company owns the property management. Therefore, counsel recommends dismissing this complaint and administratively opening a complaint against the property management company for unlicensed activity. And that recommendation is to dismiss this complaint and administratively open a complaint against the unlicensed property management company mentioned by respondent's attorney for unlicensed activity.
Motion to accept counsel's recommendation.
Second.
We have a motion by Ms. Hills, a second by Mr. Woods.
Anything going on with that police report and complaint with the Better Business Bureau? Just for information.
We don't have that information at the time. But we could. We don't have it. But if we did, it wouldn't be. It's in landlord tenant, so we don't have jurisdiction over it.
Okay, so unfortunately, the attorney thought he was helping. All right. Any other discussion? All those in favor of the motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 13.
13 is 2019-005371. This matter involves a transaction in which complainant, a licensee, represented the buyer and respondent represented the seller. Complainant alleges respondent pressured the buyer to switch from their title company to the one hired by the seller. There is apparently some confusion as to what title company would be involved in this transaction. The seller's title company representative was under the impression that they would be handling both sides of the transaction, but complainant stated their client wanted to hire their own independent company, so they went with someone else. When a respondent learned about the mix-up, they reached out to the buyer directly in an email in which they apologized for the confusion and indicated that if the buyer did not use the seller's title company, there is a strong likelihood they would not be able to receive the keys at closing. Respondent's principal broker provided an answer to the complaint. The broker stated that there was a miscommunication between the seller's mortgage company and the title company, which led the title company to believe they were handling the entire transaction. Once the discrepancy was realized, respondent reached out to both the buyer and complainant to let them know because of the confusion, there could be a delay in getting the keys to the buyer unless the buyer wanted to go with the seller's title company. According to their broker, respondent sent the email to both complainant and the buyer due to the urgency of the situation, since closing was scheduled just 2 days out. The principal broker noted that the title company and their firm are under common ownership, but this was disclosed in writing and signed by complainant when they executed the purchase and sale agreement. Ultimately, the buyer chose to utilize the seller's title company and they took possession of the property at closing. In a rebuttal, complainant maintains that respondent should not have communicated directly with their client, even if they were copied on the email, and states that respondent continued to reach out directly to their client until complainant advised they would be filing this complaint. Complainant also states respondent should have discovered the discrepancy sooner, as they notified the firm's point person a month prior to closing that their client had selected their own title company. Council does not believe there are any disclosure issues based upon the disclosure document signed by the buyer. Council also does not believe respondents' direct contact with the buyer constitutes an express violation of any provisions of the Act, but can see how respondents' actions could be viewed as a violation of 6213-312B11, which prohibits a licensee from inducing any party to a contract, sale, or lease to break the contract for the purpose of substitution in lieu of the contract, a new contract, where the substitution is malicious or is motivated by the personal gain of the licensee. Council did not find any evidence of a malicious intent or improper motive contained in the record, but would caution respondent against engaging in any similar conduct in the future. So my recommendation is for a letter of warning.
And what do we think about this one?
Do they not get keys when they close?
I did.
Yeah, but they just use that threat.
So is
They
this
were
a
threatening
TR
them.
form? On those, it usually states who's for the buyer and who's for the seller.
But you're not required by law to fill those out on the TR
No,
form.
I'm just wondering if they filled it out and someone chose to ignore it.
I'll double check. I don't recall seeing any.
Because
any
the
forms.
principal broker noted that the title company and their firm are under common ownership. So I wonder if somebody just ignored it and then threatened them.
Well, the seller can say, I mean, they can only say which side they're closing. I guess that could be a negotiating point, but to me, it's kind of a form of an inducement too. We'll give you a cheaper price, if you use us, simultaneous closing.
I don't think it's always price, though. I think it's a convenience thing.
Yeah.
And as I've taught in different places, like if I was going to bet money, I would almost bet this happened in Middle Tennessee. Middle Tennessee, we're real big into split transactions. And we have, one side at one place, one another. I travel other places in the state, and that seems so foreign to them. Everybody just closes at one place.
Yeah,
and just make it easier. And but we do that a lot here. And you close here. And then say the buyers close here, seller close here, and then after that's done, then they got to swap paperwork, and then at that point they probably got to call the top mortgage company, they wire funds.
Oh, and that's what they mean about the keys.
Yeah, and
stuff.
so and rarely will the title companies be located next door.
Yeah.
I mean, so
wow, y'all
yeah,
really do that.
Yeah,
all the time.
That's pretty common.
Because everybody wants their own licensee and everybody wants their own attorney. And
yeah, everybody have their favorites. And I mean,
was this TR form? No?
It was not a TR form.
Okay. Sorry.
I'll make the motion. We accept council's recommendation for a letter of warning.
Second.
All right. We have a motion by Mr. Wood and a second by Mr. Diaz. Any other discussion? All right, let's vote. All those in favor signify by saying aye.
Aye.
All those opposed, motion carries unanimously. Number 14.
14 is 2019-005731. Complainant alleges respondent is using an address that is occupied by a different business that has no connection with real estate. Notice of the complaint was sent to the address on file for respondent. Respondent did not submit an answer to the complaint. Council recommends respondent be disciplined for the violation of 6213-313, which is the statute which requires licensees to answer complaints within 10 days. And that recommendation is for a $1,000 civil penalty.
All right, we have a motion by Mr. Diaz and a second by Ms. Taylor. Now, I wanted to ask, what was I going to ask?
I did receive it then at the address that we have on file?
I'll have to double check to see who signed the green card, but yes, it was sent to the address and delivered to the address that we have on file, the address that they gave to us.
Okay, so this penalty is just for failure to answer the complaint, but it doesn't. I guess that's the only thing we can do. I'm just saying that obviously this company is not at this address. So I would like where it would be open-ended, where that we do get some resolution about where they are and do we have the proper address, and if not, why not? So I don't know.
I could include in the consent order language just
That would be good.
requiring them.
Okay,
to
that'd be
update
good.
it.
Any other discussion?
Well, that was going to be my point too, is in other discussion, we have a rule that they're to update their address whenever they move. What's the consequence for that? Any?
I think it might be something that we might consider in the future, making a rule about that. But we're seeing it more and more. We've seen it several times today.
And people personally, I mean, the agents particularly.
I think people think that they can get out of being in trouble too by not keeping us up to date.
And truly, I think part of the reason why you're seeing it more, in legal, we see it all the time. And I think, or at least I used to have a practice of trying to at least track these people down, but it's been happening so often that we really do not have the time.
Your resources
to
are
track the people
deleted,
down,
so let's let somebody pay for that, you know?
Yeah, so I'm just saying it's a violation.
Okay.
But there's no consequence. That's what I'm asking. Is there a consequence?
Like, could we say part of this motion is that, and, we have a penalty for unlicensed or failure to respond, but also if you don't give us a valid address in 90 days, we're going to bring this back up and we may revoke it, your license.
Well, do we know that we don't have a valid address?
Yes.
All right, so that's a violation right now. Why would we need to wait? Like on all these others. But is there anything in here, though, that says what we can...
That was my question.
I mean, wouldn't that be
Is there-
the principal broker's responsibility?
I would have to review the rules. I'm certain that it is a rule. Off the top of my head, I don't know which one it is.
Well,
Ms.
I mean-
Bridges, I'm looking at 6213-3093.
Okay.
Says within 10 days after any change of location of the office, the principal broker registered at that office shall notify the commission in writing of the office's new business address and shall pay the fee established in section 6213-308.
So the
why
fine
it's so
for
long.
that would be, what is the fine for that?
Well, it doesn't state in here what everything is up to $1,000. We're not told in this book what the specific...
Well, let's just
$1,000.
do it $1,000 each then. How about that?
Second,
All right?
All right, so attorneys,
I'm just so 6213-309, what Commissioner Diaz was referencing is talking about like change of location of the office. So the principal broker's registered agent shall notify the commission in writing. And I believe here that I don't know what I'm saying. Yeah, I believe here that it would be, we would probably need to open a complaint against the principal broker for failing to do that, because it's their requirement to do it, to notify
we know
us.
they haven't, so why do we need to open a complaint? I mean, can we just not go ahead and fine them? Or penalize them?
Well, the complaint's against the firm, so
Like you were saying earlier, if you want the action tied to the principal broker, it would have to be a complaint opened against
We
the
have to
principal
open one.
broker.
All right,
yeah, we can't.
you gonna do that,
It's
Mr. Diaz?
$1,000 civil
That's acceptable.
penalty for failure to answer the complaint against the firm and open a complaint against the broker for failure to change address.
so the broker's responsible for keeping the firm current, but the firm has a license. And all the agents can only be there if the firm has a license, also if they have a principal broker, but the firm has a license.
So wherever that firm, but maybe they moved and they just didn't change it. That's probably what's happened. So I think we're
Or it's a
cool with
set
just
right.
opening up one against the principal broker. So are we all good with that? All right, so we have a motion by Mr. Diaz and a second by Ms. Taylor. All those in favor of that motion signify by saying aye.
Aye.
All those opposed, motion carries unanimously. All right, number 15.
Okay, 15 is 2019-009451.
Go to the last line.
Sure. Respondent did not answer the complaint. The recommendation is for a $1,000 civil penalty.
Accept.
Second.
All right, we have a motion by Mr. Diaz, seconded by Ms. Hills, that we go along with the recommendation of council. All right, any discussion on that one? All right, all those in favor signify by saying aye.
Aye.
All those opposed, the motion carries unanimously. Number 16.
16 is 2019-003781. Complainant was an interested buyer, and respondent, a licensed affiliate broker, was the listing agent. Complainant alleges respondent failed to communicate their offer to the seller. Complainant was represented by their own agent in the transaction. Complainant states they were interested in putting in an offer, but they wanted to view the property one more time. On August 12th, after discussing it with their agent, complainant decided to reach out to their lender for a pre-qualification letter prior to placing the offer. They requested that in the meantime, their agent inform respondent that they were interested and would be placing the offer shortly. Then, on the morning of the 14th, complainant's agent received word from respondent that the sellers accepted another offer. A few days later, on the 17th, complainant visited the property to let the seller know they were still interested. Complainant states the seller informed them that they were still accepting offers because their current contract was a right of first refusal contingent upon the buyer selling their home. Complainant states the seller informed them that they never received complainant's offer, but they would let respondent know another offer from complainant was forthcoming. Respondent acknowledged not submitting the first offer to their client because it was far below what the client was seeking. Respondent provided text message records in which the seller expressed that they had already authorized respondent not to approach them with offers like the one submitted by complainant. Complainant submitted a second offer, but it required the seller to pay closing costs. This time they rejected with no counter. Complainant submitted a third offer for asking price, but again, the seller would pay closing costs. Finally, respondent flatly told complainant's agent that the seller wouldn't accept anything below full price, no closing costs. Complainant states they decided to let the third offer expire. The following day, with the third offer still technically pending, complainant began drafting a fourth offer to include all of the seller's terms when they received a counter on the third offer, which required complainant to take the home as is, contingent upon the outcome of the pending right of first refusal. The counteroffer did not state anything about closing costs, and complainant asked their agent if the failure to include closing costs as a term in the counteroffer meant that the requirement that the sellers pay, as provided in the third offer, still remained in effect. The agent advised that it did, and complainant accepted the counteroffer on August 22nd and received notice that their offer was officially under contract on August 23rd. On September 17th, 2 days before closing, complainant's agent received notice from respondent that the sellers were concerned about a $6,500 shortfall on their sale proceeds. Complainant realized the $6,500 was likely the closing cost that the seller wound up paying after they countered complainant's third offer without specifying who would pay closing costs. The next day, complainant states the sellers refused to sign the closing documents until the situation was worked out. Respondent claims complainant and their agent acted in bad faith, knowing that the seller did not want to pay closing costs, but hiding the fact that the counteroffer neglected to address the issue and accepting the counter anyway, but admits that ultimately it was their mistake. As such, respondent paid the full $6,500 out of their own pocket. Included with the answer to the complaint was a statement from the seller in support of respondent's claims. The seller acknowledged not wanting to be approached with offers like the first one submitted by complainant and stated they were insulted when they learned how low it was. In light of the statement provided by the seller and the remedial steps taken by respondent, counsel recommends a letter of warning regarding 403, which is reasonable skill and care, and 404.3a, which is the duty to receive and promptly forward all offers received by the licensee to the client unless such duty is waived specifically and in writing by the client. And that recommendation is for a letter of warning.
Motion to accept.
Second.
All right, we have a motion by Mr. Diaz and a second by Mr. Wood. Is there any discussion?
When the respondent ended up coughing up the money because they misunderstood that they messed up on the contract, we refer to that as a commissionectomy, is what that is.
That's what happens.
That's what happens. And I will say this too, that my company represents a builder. We've sold 180 units, this builder only will accept full price contracts. People want to still offer less. And, my agents can say we've sold 180 units. They've all gotten full price offers, but they still want to do less. We've even had some that wanted to do more, but my seller doesn't accept those because that means they're not going to appraise. So, and I have to tell my people, I don't care how mad the seller gets. Just present it to them. Just, here's another one, lay it on your desk, this. And they get yelled at and they leave. But, I told them it's better than coming here, a little yelling at by the seller. And so there are some sellers that have, there's no doubt about, we know what they're going to say before we go in there. But still, the process is the process.
Well, and even if the seller says, I won't accept it, you have to document the fact that you're not accepting that offer.
And I don't want my agents making those decisions themselves, and then the seller saying, well, hey, wait a minute. Even though he did say don't bring them in here. So sometimes you got to take a whipping. All right, so we have a motion, and that was to accept council's recommendation of a letter of warning from Mr. Diaz and Mr. Woods. Okay, any other further discussion? All right, all those in favor of that motion signify by saying yes.
Aye.
All those opposed, motion carries unanimously.
Say what you said.
It says she's paying attention.
He don't take instruction.
All right, number 17.
Number 17 is 2019-004-001. Anonymous complainant alleges respondents' advertisements are in violation of the rules because on at least one of respondents' yard signs, the team name appears larger than the firm name and features a phone number other than the firm's number. Complainant provided an image of the sign, and counsel agrees that the team name appears in a larger font size than the firm. Respondent stated that the signs were made at a time when there were no rules specifically addressing font size and firm telephone numbers. Respondent states that they are in the process of removing and editing the signs and plan to have all signs replaced within 10 days. The rules regarding font size and firm telephone numbers went into effect on June 24th, 2017, a little over 18 months prior to receipt of this complaint. So my recommendation is for a $500 civil penalty for the violation of 1260.02-.12.
I think it's splitting hairs a little bit because the rule really, I think, went into effect July 15th and it said prominent. And we had a hard time defining prominent.
I don't
and
think the rule that they're violating, it was a 2017 rule.
No, so in 2017, we tried to clarify the definition of prominent.
We loosened it up in 2017.
Yeah, so it was
Regardless, it's been
prominent.
Regardless, they've had 18 months to change their signs. Regardless, right?
Well, we will say that $500 is usually the amount that we would send an agreed citation for in an advertising violation for a first-time violation. So that's where the $500 comes from.
Move to accept council's recommendation.
Second.
All right, we have a motion by Mr. Wood and a second by Ms. Hills. Ms. Taylor. Is there any other discussion? All right, let's vote on that. If you're in favor, vote aye.
Aye.
If you're opposed, vote no. Motion carries unanimously. Number 18.
18 is 2019-007911. Complainant is a Tennessee resident and respondent is an unlicensed limited liability company. Complainant alleges respondent is practicing without a license and advertising homes for sale that he does not own, is scheduling listings and attempting to negotiate sales. Complainant met respondent at a property and alleges they realized respondent is attempting to act as a real estate agent with no knowledge of real estate contracts or ethics. Complainant believes respondent is a danger to consumers. Complainant provided counsel with an advertisement advertising a home with respondent's name listed. Respondent answered through their attorney. Respondent's attorney states respondent is a party to a real estate purchase agreement for the property subject to the complaint. Respondent's attorney states that since respondent is the principal of the LLC, respondent's attorney states that since respondent's principal of the LLC, due to a pass-through nature of this business, the principal is essentially carrying out the business of the company themselves. Respondent's attorney believes neither respondent's principal nor respondent are in violation of the act. Respondent's attorney states the purchase agreement was signed by another member of Respondent's company, and they decided to sell the property under contract. Respondent's attorney states Respondent believes this complaint was filed by complainant in retaliation for Respondent not lowering the price. Respondent's attorney states that neither Respondent nor their principal had any idea by selling property under contract to their LLC they could conceivably come under the statutes regulating real estate brokers. At no time were they acting on behalf of the owner of the property or any other unrelated entity or individual. They simply saw attractive property they could purchase and sell for a profit using their LLC as a vehicle for the transaction. Respondent's attorney states they will conduct their business differently going forward. Internal research shows Respondent holding themselves out as a real estate investing group specializing in the acquisition of single-family and multifamily properties. Furthermore, Respondent advertises on their website that they help residential, commercial, and others sell their properties quickly and smoothly with investors to give returns through short-term and long-term opportunities. Respondent's website offers assistance with selling properties, buying properties, investing in multifamily deals, and assisting tenants with their management team to find properties. Based on this information, council recommends a $1,000 civil penalty for unlicensed activity.
And that's just this one account, right? One.
Well, they're
Property?
advertising.
Yes, it was just the one advertisement that we had.
But it's on their website, and where else?
This was complainant provided us a copy of the advertisement, and there were different advertisements listed on the website as well.
And they will help people sell their property. Is that what I heard?
Right. They stated that they will help them sell their property, buy property.
So it doesn't really matter how many times it's unlicensed activity.
Yeah.
So we can't get them for ads, so. Was the complainant a licensee?
No.
Oh. Okay.
Isn't that wonderful? Here we are at the LLC.
I'm in my 6th year on this commission, and my very first day, I found out about the LLC. Many people do not know about this law. Many. But I will say this. I had to see in writing the Attorney General's opinion on this. And I think it behooves us, if the Attorney General, who's representing the state of Tennessee, gives us his opinion on it, that's the opinion we should go by. I know 10 different lawyers could give you 10 different opinions, right? But
If you pay for them.
yeah, if you pay for it. So for 6 years, we've been going by this rule. If it's an LLC, it's unlicensed activity. So, would anyone like to make a motion?
Motion to accept council's recommendation.
Second.
We have a motion by Ms. Hills and a second by Mr. Wood. Any other further discussion? Hearing none, all those in favor say aye.
Aye.
All those opposed, the motion carries unanimously. Number 19.
19 is 2019-009781. Complainants are owners of rental property in Tennessee, and Respondent is a licensed broker. Complainants allege that Respondent is in breach of their property management agreement. Specifically, Respondent has failed to send a rent check or a statement in the past 3 to 4 months. Further, the Respondent has been non-responsive to their communications as complainants seek to change to a different property management company. Complainants claim that they are owed more than $7,000. Some of this amount includes instances where the Respondent paid for at least one tenant's rent out of proceeds due and owing to complainants. Respondents claim that complainants are not owed as much as they think they are owed. However, Respondent admits that the invoices were not always in order. Respondent states that they were behind in some collection efforts because they were trying to help the tenants by covering for them, and it backfired on them. Respondent also says that they did not collect security deposits from some tenants, and those tenants already lived at the apartment when Respondent was hired. The recommendation is for a $1,000 civil penalty for the violation of 6213-403-1, which is a failure to exercise reasonable skill and care.
Move to accept the recommendation.
Second.
All right, we have a motion by Mr. Mullen and a second by Mr. Diaz. Is there any other discussion?
I'm trying to understand at the very top where we're talking about. So does that mean that they're currently suspended because they didn't have E&O?
Yes.
Were they suspended at the time that this violation took place?
No.
Okay, well, if they didn't, so the E&O, so was the person first licensed
So
this year?
they were first licensed in 20.
Oh, it says 19.
That's not right. That should not be a 19. I'm probably sure that's 2018 at least. Wait, hold on a second. Let me get these numbers. Pull this up real quick.
While you're there, we want to see if there's been another principal broker appointed to take their place since they are suspended.
If you need a minute, we can skip and go to another one. That would help. Okay. Let's skip to another one.
All right, all right, number 20.
This takes us into the represent territory. 20 is 2018-006751. Respondent is the principal broker in the above related matter in which an affiliate broker under respondent's supervision lowered the sales price for a home being sold as part of a divorce without the authorization of both spouses, believing they would discuss the price adjustment amongst
Could
themselves.
you move down to the new information?
Yes. The
Please.
new information is respondent provided the legal division with evidence of their compliance with the terms of the consent order, but upon receipt of the certificate of completion, legal counsel realized that the terms of the order required respondent to take a core course without specifying that it be a principal broker core course. Seeing that it was counsel's error and no fault of respondents, and the fact that no additional complaints against respondent have been received, counsel recommends the commission authorize the closure of this matter.
Accept the recommendation.
Second.
Any discussion? All right, no, wait a minute, we're on number
20.
All right, we have a motion by Mr. McMullen and a second by Mr. Diaz. All those in favor of the motion, vote aye.
Aye.
All those opposed, motion is unanimous. All right, number 21.
21 is 2018-071931.
Go to new information, please.
The new information is counsel was finally able to serve the respondent. Respondent disputes complainant's characterization. Respondent did receive referral fees, but says they did not participate in any negotiations as those are prohibited under Section 302. In rebuttal, complainant states that while respondent does employ a Tennessee broker on their Tennessee deals, the broker is just a rubber stamp and that the actual work is handled by the out-of-state broker. But there is no evidence in the record to support this claim, and the recommendation is for dismissal.
Move to accept the recommendation.
All right, we have a motion by Mr. McMullen and a second by Mr. Diaz. Any discussion? All right, let's vote. All those in favor, vote aye.
Aye.
All those opposed, motion carries unanimously. Number 22.
22 is 2018-068101. The new information is respondents sent information via their attorney stating that they believe they are exempt from any licensure requirements as respondent has an ownership interest in the apartment complex. They feel they therefore fall within an exception to the general rule requiring a real estate broker license pursuant to 6213-104A1, and that's the owner exemption. A previous attorney for the department agreed to bring this complaint forward to present the new information for the board's review. The recommendation is discuss, and our chief counsel Mickens actually wrote this one. And the reason that he put discuss on there was we've been really looking at this owner exemption, who can qualify as an owner. And we've worked with some other attorneys, and the determination has been that owners of owners do not count for an owner exemption. So if you
I
say,
mean, owners of owners.
if a company owns
The company.
a company that
Okay.
owns property, that first company that just owns a company, they do not qualify for the owner exemption. We also determined that if you only own a percentage of the property that's being transacted, then you can qualify for the owner exemption, but only insofar, or only to the extent that you own the
Shares.
property. So you can broker your 35%, but if you're brokering the entire property, you're brokering 65% for other people. So I think the recommendation really here is to maintain the commission's previous decision, but we wanted to just discuss that owner exemption a little bit on the record.
Do you know what kind of ownership they had?
In this case, I believe they own the company that owns some of the property.
LLC?
Yes.
All right, so here we have the previous, the commission voted to issue a $1,000 civil penalty for engaging in unlicensed activity, which is consistent with what we've done all day today.
Move to uphold council's original decision.
Second.
So it was the commission's decision. Okay, all right, so we have a motion by Mr. Diaz, second by Mr. McMullen. Any discussion on that one? All those in favor, vote aye.
Aye.
All those opposed? Motion carries unanimously. Now, can we go back to number 19?
Yes, we can. So that should be, they were first licensed in 2010, and their license expired in 2020. So at the time of this complaint, they were suspended for E&O, but that has since been rectified on 7/5/2019. So they are no longer suspended. So last week. So at the time this was written, they were suspended. They are not suspended anymore.
At the time of the violation, were they suspended?
But at the time of the violation, no, they were not suspended.
All right, so we had a motion by Mr. McMullen, seconded by Mr. Diaz, to accept council's recommendation for a $1,000 civil penalty. Is there any discussion about that or any changes you want to make? Hearing none, let's take a vote. All those in favor of the motion, vote aye.
Aye.
All those opposed, motion carries unanimously. Thank you to our attorneys.
There is one more legal matter to discuss. I'm not sure if it made it on the agenda, but there was a hearing scheduled for tomorrow, but that hearing, or that case was settled. And so I think Chairman Grease wanted me to talk about it and to possibly take a motion on signing the order.
Okay.
So essentially, this was an authorization for a $500 civil penalty stemming from a new licensee's error. They didn't ensure that their transfer and release form was received by the commission before they started working at their new firm, which is a rule violation. And then 2 years later, when they come up for renewal, the renewal notice that we sent out went to the first firm because our records still showed that they were at the first firm. So they don't get the renewal notice, they don't renew, and then they got a complaint filed against them for unlicensed activity. They did renew within the grace period. It was only a few weeks of unlicensed, but it was. And again, there was also the violation of failing to ensure that the form had been processed before they started. Ultimately, we were able to get them to agree to pay the civil penalty that was authorized by the commission, and that is what this agreed order provides.
You need to know if we agree that Chairman Grease should sign that order or not. Okay, is there a motion?
Motion to approve the resolution.
Second.
All right, any discussion? All right, all those in favor, vote aye.
Aye.
All those opposed, motion carries unanimously. Excuse me. So he can sign it.
And that's all from us.
Great, great, good job today, thank you.
From me. They have more.
It's under commission discussion, so we're
Okay. All right, so now we are done with the legal report. We're going on to commission discussion. First, we're going to have a discussion about the 50-mile rule. Diane asked to have a discussion.
I've been approached for a long time, and it's come up again, and it's not just from my area, it's from across the state. And it's been from brokers and from licensees that are frustrated. And even when I go to convention and things, this just seems to be brought up, that they thought it was a bad idea. I thought it was a bad idea at the time. I'm the one that made the motion. It seemed that the state wanted it done. I think it's caused more, or I personally, I'll give my opinion, and then what others say, because I asked, what is it you're talking about? So, they don't know. Like last night, I had to make a phone call to someone else, and another broker. I happen to know who they are, and because it's locally. But for me to find out who the broker is, they're companies, model plans that, and this is not picking on one, but this is just the biggest example. There's one broker in Nashville for all these licensees across the state.
How many?
I don't know. I have no
Thousands.
idea. Yeah. And the broker is in Nashville. Now, when I look on our MLS for the ones that are in our area, they may show Knoxville as where the principal broker is and give an address. So the agents themselves that can work at a company, they don't even know where their principal broker is. So how's the public to know? How are we to know in trying to deal with them? Now I'm not picking on the one, because it's other issues too. It's just other issues that I think it's just made it like herding cats. I mean, you can't find the answers, and the agents themselves don't even know who their principal broker is. There are offices that exist that are satellite offices without, and the agents will say, stop by my office. Well, there's no broker at that location. And that location's not even with the state. These are the things that rule, I think, has allowed to create. So I just wanted to bring it out. I mean, those are things I've heard. Has anybody else heard or seen anything like that?
Yes. Yes, I'm aware of one brokerage where their main office, and on the contracts, they list the main office in Nashville as where their broker is, even though the transaction itself is occurring in Memphis between the two agents that are both in Memphis. But the one side of the transaction has their office is listed as being in Nashville. And even if they have a local office, if you write on the contract their local office, they change it to the main office in Nashville.
So how do they have a local office if their broker's not there?
So
See, that's the thing. It is.
Do they have a sign out that says the company name on it, or does it say Marcia Frank's team?
well, in this particular instance, I haven't observed their office location personally. I just thought it was odd that in the contract it went from the local office that is listed in the MLS for that agent, and then changed to the branch office. I guess
So the local
main
office
in
could be
Nashville.
their home, because if they don't really have a firm license, they don't have to have a letter showing that they're in a properly zoned area. So they may just be semantics, their office is.
One could assume that. Yeah.
Well, that would be an issue then, if they're listing a office in Memphis that is not an office in Memphis, then that in itself is an issue.
And so we look on, like on our MLS, when they apply for MLS membership, they put their office address and things. So it can be Knoxville, it can be another town, and it won't even be the town that the state represents that should be their principal broker.
Well,
I just
I think there's another issue is, I think our rule was only that an agent didn't have to live within 50 miles of the office. We have no rule about a broker having to live
And that
with
was
a broker. And that, to me, is that is the prime problem. The agent living within 50 miles is a secondary problem. But the big one is you can have a broker anywhere and have an agent running around.
But nobody statewide seemed to think it was important that the broker, because we had one in our area, that the broker's in Florida.
That's, to me, you cannot oversee somebody, and of course we've seen examples in here already about brokers being more than 50 miles or absentee in a lot of cases, trying to oversee somebody here, and that's, yes, I know it was made because it made life easier, quote, in today's word of internet and stuff, but it's not. It may be easier to do it on a computer, but you still don't have the oversight, and you don't have the, if the agent lives more than 50 miles an hour, you know they're not going to the meetings, they're not going to go to the classes, they're not going to interact. If the broker doesn't live there, that's even worse.
So this is not just a Tennessee problem. Virtual offices is what they're called, and we discuss it at every Arello meeting. No one seems to have an answer for it in the United States, Canada, and 14 countries. So everybody's dealing with the problem because they're commissioners and they're commission attorneys and such. Nobody's really come up with what do we do with this business model. Because at this point, they're not breaking any laws. They may not be in the states where they have a 50-mile rule. Probably not.
Well, if they have a they have an office, they've
got an office in Tennessee, but
yeah. But if they have an office in Jackson,
I don't know.
I
don't know.
There are locations.
Well, and it's interesting because I had a long conversation with a client yesterday. They're moving from Atlanta to Memphis, and she asked, are you able to represent me in transactions other than Shelby County? And that the 50-mile rule came up. I said, my license allows me to sell real estate anywhere within the state of Tennessee, but the rules are not within a 50-mile radius because I don't know the Nashville market. I don't know the Knoxville market. So
that's your rule or your broker's rule,
yeah.
not a state rule.
Yeah, the 50 miles is within.
That's been overturned.
Okay.
We don't have that anymore.
Yeah. And so therefore we have no auditors that walk in and make a surprise visit. So if an auditor comes to town, they used to come to town and everybody said the auditor's here. And you just, everybody said auditor's here. But now there's no auditors. So for an auditor, we have no one that will stumble in on what appears to be a real estate office that's not registered with the state or has a broker at that location.
So, I mean, it's. I don't see it as our job to decide which business models are good or bad. I think our only thing as commissioners that we do is that we make sure that they meet all the standards of law and rules that we have. Now, if we want to change rules, we can do that. You know how hard it is to get a law passed. Anybody got an answer?
I don't know that I have the answer, but this whole thing came from we had a broker that talked to us over the by phone, and he was, if I'm not mistaken, living in Arizona but brokering an office in Memphis, and that
in 25 states.
Yeah, oh, yes, and so that kind of started the conversation. And I think I asked the question, well, what's the rule? We know what agents. What about doesn't he have to live within 50 miles? And the rule, there was no rule for the broker, and so a motion was made to let brokers make them live within 50 miles. And the rationale for the 50 miles is it's supervision and training,
Right.
And we was kind of like silly. If the agent's got to be within 50 miles, why shouldn't the broker? Because they're going to have to be leading the training usually. You hope they are. They're responsible for it. Well, we tried that. We didn't pass it. And then somebody made the motion and said, well, since we're not doing it for the brokers, let's take it off the agents. And that's where it happened. I started getting feedback probably within about 60 days of it actually happening. People going, what were y'all doing? And my comment was, well, when they send out the notices by email and saying, does anybody want to comment? They didn't really get any comments, but the comments came up after the rule came into a place. So I think we usually do a good job. I think we messed up on that. And I'm not ready to go, boy, vote on it today. I think it's a big enough thing we want to think about. But I think we made a mistake there, and I'd like to see us revisit that, maybe even as early as next month. Just give us a time to think about it. But 'cause I think it's a big deal.
And maybe you can do some research on maybe asking who's your broker, what's your broker's name, those kind of things. And if they don't know, then we have more to work with.
Well, I wonder, getting a license is a privilege. It's not a right. So I wonder if a residency requirement for a broker's license would be something that, at least a measure that might.
That would be statute also.
That would be statutory. So I would, if I can interject and just add some things, we have a rule, so 1260.02-.011, it's on page 82. It says, no licensee shall engage in any real estate activity in any office unless there is a principal broker who devotes his full time to the management of such office. So it sounds like what you're talking about, principal brokers not being at these offices, that they may be indeed in violation of this particular rule right here.
If they are really offices. That's why I'm saying maybe they're saying, you can rent an e-space,
right,
and that be your office, but it doesn't mean that's a real estate office, but that could be your office.
Well, it says any office. So also we have requirements for offices in our rules as well. So then that would be something that we would also need to look at. And I'd also want to state, I know this is something that we might want to look at, but we also might want to look at the amount of complaints that we've received concerning this. I know you're speaking of a lot of complaints within the industry, but complaints specifically from consumers that have been harmed by this, because consumer harm, we are a consumer protection industry. We want to make sure that the consumers are protected.
But if you go just by that number, most of the consumers don't know what to do, and if they don't know to call the principal broker, or even if they knew to call a principal broker, they wouldn't know where to find them.
Right, and so I think that might also, if that's the case, be an educational piece that we're missing from our licensees that we also might want to address in that part. But if we're having principal brokers that aren't following this rule, then we would need some kind of indication that lets us know that they're doing it. It's good to have conversation. Conversation is great, but we need also tangible numbers so we can have tangible results of these types of things as well. And so if we don't have complaints or anything that is showing consumer harm versus industry harm, it's going to be hard to justify making some kind of new rule or some kind of new regulation without anything to support that.
Yeah, but just because somebody didn't complain that this is a brown desk, I know it's a brown desk, Right. So complaints to me, numbers of complaints that come into your office, that isn't everything to me. That isn't everything to the licensees in the state of Tennessee either.
Right. I understand it's not to here, but our rules have to be approved here, and then they also go out to the AG's office. They have to be approved by the governor's office and by the legislature's office. So the legislature and the governor's office and AG's office are not only going to look here of what it's being impacted by the commission, but they're also going to be looking how it's impacting the consumers in which our industry is serving. So it may not mean a lot here, but if we were to somehow do something about this, that's definitely going to be something that we will need to provide to them to prove that this regulation would be something that's important and something that would need to be done. So I know we're not necessarily talking about anything. We may want to just have another discussion, as we were saying before, for another month or so. I can do some research on the back end, see if we have any complaints, and I will make sure that I specify. I'll look at consumer complaints versus competitor industry filed complaints to see if we have any of those things. But we'll need to have a lot more discussion whether we're going to do this, because right now it seems like we have violations of this rule here that we have in place, but
nobody's filing complaints.
Nobody's following it.
Because they don't know how.
So,
go ahead. I
go
didn't
ahead.
interrupt. My initial impression is that the elimination of the 50-mile rule is a convenient scapegoat for every time somebody has to deal with another broker or affiliate who's unprofessional or makes some mistake in their contract or something like that, lists the wrong office, doesn't know what they're doing, is an idiot, whatever. My initial impression also is I don't see that reinstating the 50-mile rule is going to result in more supervision of people, particularly when we have specific rules that are already in place. Ms. Matlock talked about one of them. I would encourage everybody in their free time to also look at TCA 62-13-309. It's on pages 37 and 38 in this book. There's some interesting things in there about each office being required to have a principal broker. If a broker maintains more than one place of business in the state, they have to apply for and obtain an additional firm license for each office. A principal broker may act as a principal broker for two firms, but only as long as both firms are in the exact same location. And same location means they are located at the exact same physical address. And then, in addition to the rule that Ms. Matlock referenced, you could look at Rule 1260.02.03, Part 3, which is on page 84 in the book. And it defines branch, which is basically the same as office, to mean any place where somebody advertises the office in any manner for the purpose of attracting the public, has a mail drop at the office that's registered with the United States Postal Service, or invites or solicits telephone calls to the office. So, I think that's pretty broadly defined, and if people are listing these different offices and contracts and things like that, then that could be considered an office, and you got to have a principal broker. It sounds like a different principal broker for every one of those. So is that being violated? If so, maybe we ought to look at enforcing that rule before we go out and consider reenacting an old rule that we already got rid of once, that to me seems to have a very tenuous impact on supervision, when there's a lot of other supervision and office-related rules that we could enforce that are already on the books.
I agree.
I agree 100%.
With Commissioner McMillan.
The thing is, I think that getting rid of that made that fungus grow. I think that was the trigger point. But you're right. The problem we have is this other stuff. No matter how.
I think it's just easy for people here. They got rid of the 50-mile rule, and maybe people thought that was a good rule, and they never told us that. But okay, they got rid of the 50-mile rule. Well, then every time after that you have some numbskull that you run into, you say, "See, shouldn't have got rid of that 50-mile rule. That's why that numbskull's out there." And I don't know. Maybe that person lives within 50 miles of their office. I don't know. Who knows? And just because you had a 50-mile rule doesn't mean that person's going to pay any attention to what somebody tells them to do.
And I agree. I think the rules that are being broken are already on the books.
And I
agree.
I see here, I don't know if it's this is something we could talk about in the further discussion, as this being an educational opportunity for our other agents, specifically our principal brokers. We have lots of different methods of communicating with them to let them know if they are having these issues, or if agents are having these issues. There are certain rules and provisions that are supposed to be in place that these agents can rely on, and these other agents are supposed to be following. And if they're not following, then we need to hear from them, because we can't fix problems unless we hear them. So there are lots of things that are here in place that I think that can help mediate these issues. But I also think that maybe, I don't know, we could create some kind of publication that could be something that we include in the next newsletter, or we could have a mailer that is completely separate that goes out to, we could have a specific mailer for affiliate brokers, a specific mailer for principal brokers, telling them that, hey, supervision is really important, you guys have to do this, and this needs to be done, and cite the different rules and statutes. But those are just a couple of different ideas that I'm floating.
I think just the newsletter and citing these things.
Do we know, I know there was a spring newsletter. Are we anticipating there being a summer newsletter?
I was going to do like a summer/fall, like September, October.
Oh, a fall, not a summer.
Summer/fall.
If we need to make one, I will get on that.
Yeah, we could work on putting something in the next newsletter if that is something that we want to do. But if we want broader reach, because not everybody is subscribed to e-Notify, that's something else that we can talk about too.
Well, and I wonder, there is a broker's core class, yes? I wonder if Mr. White, is there some way that we can ask the industry to provide a module on these rules for the broker's core class and make it part of that curriculum?
I think maybe just more like a blast to the individuals that are teaching the principal broker core class.
That's just
like,
a few
hey,
people at this point.
Is this something you might want to include in your curriculum?
Right. I think, something that says the commission would like these sections of the law emphasized in the classes.
Put it out to them in an announcement or notice.
Their license, so we need the present brokers to know in the presentation.
What happened was there was a change in a business concept, and it went towards teams. So we had that, and we've dealt with that as best we could. Now there's another one that's this virtual. And it actually encourages people to. It's for people who want their own business, but they don't want to own a firm, or they don't want to be a principal broker. They just want to own their own business, and they can hire people underneath them, and they can have teams. Actually, most of them do. So I think the biggest problem is the supervision, and that's the biggest thing that we need to be looking at. Is the lack of supervision when you've got thousands of agents and they have one office in Nashville. So I think, why don't we just say, let's all think about this. Let's see if you can do any investigating, or if you hear of anything, or if you know some people that are using these models, find out, what's the pros and cons of them. Maybe we could have a more informed discussion if we did that.
A lot of times our association of realtors are kind of the first. They're on the front line when to catch complaints before we even hear them, and so that might be a good exercise for us to ask our associations or any entities we're part of if they're hearing anything, or if it's just in our imagination. But I also think this too. I think I'm not convinced that the 50-mile rule has done all this when we did away with it. But there is a movement right now of when most of us came along. We learned real estate from our brokers. We didn't get it in real estate school. We got it from our brokers, and our brokers are the one taught us to do things, and we got to see them on a regular basis. But now you have a lot of people that want to be brokers, but basically in name only. And I'm not saying all of them, but a lot of them. And they want to be the broker, but they don't want to communicate to their agents, and they don't want to answer questions, and they don't want to hold earnest money because there might be some liability. I mean, they don't want to do nothing, and they don't want to train.
And you can
And,
see
uh,
monthly, those numbers of people becoming brokers is way down.
I mean, I was out of town last week. I had 2 agents from different companies text me asking me questions. And I said, hey, I'm on vacation. I said, if it can wait till Monday, I'll be back Monday. I said, but I suggest you contact your broker.
I always say that first.
And one of them ended up calling back a second time with another question saying, well, now my broker's on vacation. What can I do? And I said, wait till Monday.
Yeah.
You know?
I'm not your broker.
You know.
Because then they might use that against you
Yeah,
and
so-
say, well, Bobby said.
So I think we all think about it, and let's
Yeah.
talk again next month.
All right. So,
Sunset?
and then we got to talk to Miss Anna about the sunset rule hearing.
Yes. So we have a sunset hearing coming up on August 21st. It's going to be before the Government Operations Joint Subcommittee on Commerce, Labor, Transportation, and Agriculture. So we are in the process of preparing written statements to submit to the committee right now. And during this hearing, we will need an individual of the commission to attend with us to this hearing. So typically for some of our other boards, we usually go with
I think John Grease has his hand up back
the
there.
chair or the vice chair, the chair or vice chair in these circumstances.
Now it's going this way.
To come with us. So,
And who is us? Who will that person be? Last time
So
it was
I-
Brian McCormack.
So I think I will be there. I think Caitlin is possibly going to be at the hearing as well. There will be a conglomeration of a cast of individuals coming with us.
Who took the place of? I wasn't here
So
last week.
we have a
new regulatory board.
We have a new assistant commissioner, Toby Compton, and
Toby Compton.
we met Toby last. I don't. You guys weren't here. I don't
Yeah.
think to meet.
I wasn't
Toby
here last time.
Last time. I'll have to see if he can come down to the August meeting so you guys can meet him in August.
He was here at the beginning of the meeting last
Yeah,
month.
he was there at the beginning of the meeting. So we have a new assistant commissioner. So does our chair or vice chair maybe lives in
I'll do it because I
Nashville?
live close by.
Want to do it?
Austin went with me last time because he was an attorney, and actually Brian McCormack did all the talking pretty much. I mean, they asked us a few questions, mainly why aren't you spending the money, but be prepared for that.
What's the status of the fee change, fee reduction that we?
Great. Fantastic. So those rules have been approved by the governor's office after the moratorium. They are at the attorney general's office waiting for signature. And I followed up with them last week again to see where the signature is. I will send them another kind email today. My goal is to have those rules filed with the Secretary of State before said hearing. If that means I have to go to AG's office myself. So that's where the status of the rules are.
I think
That
Toby
would be
Compton
helpful.
needs to go to that meeting.
The sunset hearing?
Yes.
I think he's planning going, but I'm not sure. Either he'll probably maybe be there.
Because his other boards will be there also.
Yes, it's not just us. We have a couple of other boards that will be there. Okay, so
I'll do it,
We
but
need volunteers.
Voluntold.
Miss Marcia
I'll be
Franks.
around.
Austin will go, he said.
Oh, good.
What time is sunset on August 21st? Like
No.
7 o'clock at night, 8 o'clock at night?
Last
No.
time
we have
we had to
drinks?
leave at 10 o'clock in the morning and left the meeting, remember?
I usually like to have
9
maybe
a.m.
a clear
That's a day.
beverage.
That's a day.
You know, to drink some ice to drink
Water?
at sunset.
At 9 a.m. It's at 9 a.m.
9 a.m.
That's a dad joke.
Red or white? All right. So are we cool with that then?
Yes, I'm good with that. Thank you.
Okay, so might be nice for us to have a little discussion before we go up there about the status of everything.
Sure, no problem. We can talk about
And,
it.
and it's,
If I'm still on this board at that
yeah,
time.
and it's going to be about the money, so make us well prepared about the money and why we haven't spent it.
We'll talk about it.
Can't spend it. They won't let
I
us
know,
spend
I know.
it. That's the reason.
All right, so
I got
Chairman
things to think
Grease, we love you. and we hope you feel better.
Motion to adjourn.
Does anyone
Second
have
motion.
anything? Bobby, you have anything to say?
Good.
Austin, you have anything to say? Diane.
Chairman Franks.
Thank you. Mr. Diaz? Ms. Taylor?
Always have things to say.
Okay.
But not now.
No, but no.
All right.
Thank you very
Thank you, everybody. We appreciate the office is doing a great job, and we're really proud of how y'all are holding things up. So, see you next month.